Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And we are here with our continuing coverage of the Paxton impeachment trial, where Ken Paxton is on trial to be thrown out of office for various misdeeds that he may or may not have done in relation to a real estate developer in Austin. The allegations generally being that Ken Paxton used his office to benefit someone for political favors, that he used the powers of his office corruptly to benefit a particular individual named Mr. Paul, who is a real estate developer in Austin who fell on hard times, and used the power of his office to assist Mr. Paul by, for example, forestalling bankruptcies that he would otherwise undergo, or foreclosures perhaps more to the point, relating to his properties, or harm his competitors, or tried to cover it up, or retaliated against the whistleblowers who tried to expose it all. These have been the allegations. So far, we have heard from one witness. The one witness was the first assistant attorney general in the attorney general's office. We have heard both during direct and cross from this witness. So far, what we've heard from this witness, in direct, we heard the idea that Paxton, according to him, of course, this is all his testimony, and I'm paraphrasing, so you'll forgive me, but that Paxton, he observed, doing things that you wouldn't expect the attorney general to do or wouldn't normally do. For example, he wanted to make a personal appearance at a court process that was occurring in Travis County District Court. This case was not of particular importance or prestige. There was nothing, notable about it. It wasn't a major news story. Didn't involve issues that, were central to Texas or anything. It was just a run-of-the-mill case. So there's no particular reason for the attorney general to make a personal appearance, would be the idea. But he was going to make a personal appearance until talked out of it. And the personal appearance was to appear at a trial hearing that involved his friend, Mr. Paul. The idea being that he was trying to show him favoritism. Also, that he signed a contract relating to hiring someone that went outside the normal protocols and procedures that the first assistant did not approve of, and other people in the office didn't approve of, in a way that was meant to help benefit Mr. Paul. This was an external guy, the idea being I was hiring this guy externally to do an investigation because he would be my patsy, and he would do the investigation and, clear things or otherwise massage things rather than it being done internally. That was sort of the generalized allegation. Also that, that he otherwise went outside normal procedures or protocols to benefit Mr. Paul. These were sort of the generalized allegations we heard. Overall critique from the prosecutor, this guy named Rusty, whose name I apologize escapes me. Rusty is a little bit not. He apparently at one time was a very good lawyer in Texas. Apparently at one time he was a very, very notable trial lawyer in Texas. Unfortunately, in my evaluation, he seems to have lost a step. His direct could have been at least 20% shorter in time, but not lost any substance. There was a lot of wasted time, in other words. And also the nature of the questions were not particularly great to facilitate the answers. So I think the witness overperformed the lawyer that was asking him questions, but that's okay. And then we heard from Mr. Buxby, lawyer for Mr. Paxton, who is destroying the first assistant attorney general in every possible way. And I posted a clip during lunch where he destroys and tears out his soul, because that's how well it's going. So he definitely did a lot to say that, this guy, made a lot of assumptions, didn't check his work, acted hastily, didn't ask Mr. Paxton when he could have, did things that were improper, for example, by taking Ken Paxton's name off the letterhead, which, that's kind of, not good when he is the AG, but took his name off the letterhead and did other things that were kind of weird. And you didn't really look into everything all the way. And even though supposedly, this guy's your friend and all the rest, you didn't investigate it properly. So a lot of that stuff that was happening. So that's kind of the general tenor of everything that's happening in this case so far. Yeah. And then, insults the man because he didn't get his federal judgeship, which, that's a blow. That's a blow on a man's ego, you know. You get nominated for the bench, and then the Senate turns you down. That's got to hurt a man's soul. You know, I've never had the privilege to be nominated, but I imagine being nominated and then, you know, rejected would be quite the blow to one's ego. But it's okay. He never wanted to be a federal judge. He wanted to work at First Liberty instead. Okay. Sure. So that's sort of where we're sitting on the thing. I think that the prosecution is in real danger of running out of time at this pace. Because I think, you know, they need multiple different people. They need, you know, I think they need, because, you know, if this was happening, and like there's apparently a bunch of people that had to sign off on this contract that the Attorney General just signed, which, you know, this was also great too, where the first deputy AG, or first assistant AG, or whatever his name is, whatever his proper title is, says this is a void contract. It's like, what are you talking? This is a void contract? Yeah, I would have considered the contract void. Why? Because, you know, because even the Attorney General is bound by the law, and I didn't think it was in the best interest of Texas. What? Like, what?
All rise. The court of impeachment of the Texas Senate is now in session.
It was, yeah. It's like, okay, so you weren't elected to office. You weren't the AG. And your reasons aren't the contract is void because bribes. Your reason isn't the contract is void because, you know, something else. Your reason is because, in my judgment, it's not in the best interest of Texas.
We continue.
All right.
Your Honor, good afternoon. I want to kind of get this timeline correct so we can get it all right in our minds. You found out about the bank subpoena from Kamek on the 29th of September 2020, right?
That is correct, sir.
And this meeting you had with the top lieutenants was what day?
It was the same day, sir.
So on the 29th, on the 8th floor, y'all got together and had a meeting about the subpoena and about Nate Paul, etc., correct?
That is correct.
What happened in the date order next, on the 30th? Is that when you went to the FBI?
Yes, correct.
Okay. And then you sent a text to the Attorney General?
We did, yes, sir.
What day was that sent?
That was the next day.
What next day?
Well, the October 1st.
Okay, October 1st.
Yes, sir.
And then you resigned October 2nd.
That's correct, sir.
All right, just so I can get it in my mind. You learned about the subpoena on the 29th of September.
Yes.
Y'all met the same day.
Yes.
You went to the FBI the next day.
Yes.
You sent a text on October 1st the next day.
That's correct.
And you also all of you signed a letter, correct?
Correct.
And then the next day you resigned.
Yes.
Okay. So, just so in case the jurors are wondering about the timeline, and maybe they'll wonder, go back, Eric, if you would. Your Honor, one thing I want to mention. Eric, would you stand up? You hear me say Eric. Your Honor, this is Eric Arroyo. He's our audiovisual guy that works at our office. In case you were wondering who I was yelling at over there. All right, Eric, would you, AG Exhibit 170, go to Brickman 187. And let's just try to confirm in our minds that the documents match up to the timeline.
Is there a problem in the timeline?
Page 187. Okay, here we are, and I think everybody can see this. We have a major problem. The kid has served a subpoena on a bank, showed up there in person at the bank with someone from World Class. I need you guys to come back. You wrote that in text, true?
Yes, sir.
And that was on the 29th, right?
That's on the 29th, yes.
Okay. The next day, you went to the FBI, September 30th, true?
That's true, yes, sir.
And the next day, October 1st, you sent General Paxton a text.
Yes.
Let's look at AG Exhibit 127, Exhibit 31.
What's going on here? It's like, I know I'm being set up for something. I'm not sure what it is yet, right?
Okay, here's the text. This is the text. You deleted this text, right?
I had received a copy of it from Miss Mace.
Okay. And this is the text you sent the general
Yes, sir.
on October 1?
Yes, sir.
Okay, and then the group of you folks then signed a letter, is that right, on the same day?
Yes, sir.
Let's go, Eric, if you would. Same exhibit, Exhibit 1. We're looking at Exhibit 127, Exhibit 1. Very tedious, but we got to look at this.
It's laying a foundation for
We
something.
really need to break these out so this doesn't take this kind of time. Okay, here we are. This is the letter that the let's see, 1, 2, 3, 4, 5, 6, 7 of you signed, right?
Yes, sir.
And that was on October the 1st, true?
That is true, sir.
Okay. Let's take a look. Keep that October 1, 2020 date in your mind. Can you do that for me?
I'll try, sir.
Okay, let's look at AG Exhibit 434. You see that? That's the bar record of George P. Bush. You see that?
I see what the document is. I think everybody can.
Now look at the bottom. Look at the bottom entry. His law license was inactive for 10 years. See that? Look at when he requested to reactivate his license. Tell us all that date.
Where you want to point it to me?
10/1/2020. Do you see that?
I see the document says that, sir.
What date is it? When he applied to activate his license.
It says October 1st, 2020.
Huh. Let me get this right in my mind. On October 1st, 2020, you sent the general a text that we saw, right?
I did, yes, sir.
On that same day, you signed a letter, 7 of you, right?
Yes, sir.
And coincidentally, on that same day, George P. Bush, who ran against General Paxton, did he not?
He did in the primary.
George P. Bush applies to reactivate his law license. You see that?
That's what that document appears to say.
You ever hear that old saying, there are no coincidences in Austin?
Actually, I'm not an Austin guy, so no, I haven't heard that one.
There are no coincidences in Austin. You never heard that?
No, I haven't.
Okay. Now I'm trying to figure out the connection here. Before October 1st, you had already talked to Johnny Sutton, hadn't you?
I had not.
Somebody had, right?
I believe so.
Somebody within these 7 people had, right?
I believe so.
And what's Johnny Sutton's relationship with George P. Bush?
I have no idea.
Don't know.
Any. I have no idea if there's any.
No clue.
No.
So the day after George P. Bush applies to reactivate his license, you resign. Is that right?
I resigned on October 2nd, sir.
Let's look at that. That is House Manager Exhibit 291. Bring that up on the screen, please.
I mean, it is a pretty interesting coincidence, I suppose, that a guy
House
who ran against
Manager
the AG
Exhibit
managed to
291.
renew his license that had been dormant for 10 years on that particular date. I guess that's maybe suggestive of something. But it's a little innuendo-y.
Second
and that
page,
doesn't quite
please.
seem like his style. He seems like more of the surgical kill style.
That's your resignation letter?
So
Yes, sir.
I'm kind of hoping it connects somewhere else because it doesn't seem like his
before
style.
you resigned, you talked to people at the governor's office?
Yes,
Who?
Your Honor, is he going to offer it? Because this is not in evidence,
Which one?
the exhibit you just put up.
House Manager Exhibit 291, to the extent it's not in evidence, I move for admission.
It's admitted.
Thank you.
Now, let's get back to the subject at hand. Who at the governor's office did you speak to before you resigned?
well, a couple of days before, we met with, I believe it was Jeff Oldham, who would have been, at that time, the governor's general counsel. I believe James Sullivan, who was at that time deputy general counsel. And I believe the chief of staff, Louis Sines, was in the meeting as well.
Was anyone else in the meeting?
Other than myself, and I believe Mr. Bangert and Mr. Brickman. I believe that's all.
Did you talk to Mr. Hodge?
No, he wouldn't have been in that meeting. He wasn't at the governor's office at that time.
Right. Did any of you, the group that you know of, talk to Mr. Hodge?
Not that I'm aware of.
You know who I'm talking about, don't you?
I know who Daniel Hodge is. Yeah, he was at one time the governor's chief of staff, but by this time, Louis Sines was chief
Right.
of staff.
Daniel Hodge is a lobbyist?
That's my understanding.
Sure.
All right. It's a little weaker
Why
here.
did y'all refer to yourselves as the Cool Kids Club?
Well, I mean, come on.
I don't recognize that.
You don't recognize it?
I don't.
Okay. Go
That's
back.
not fair.
Eric,
That's not a fair question.
to AG Exhibit 170.
Not a fair question. I'm in the Cool Kids Club. That's not nice.
Your testimony is that you folks, you 8 folks, never referred to yourselves as the Cool Kids Club?
My testimony is I don't recall me ever using that.
This feels a little petty.
How about the others?
Sitting here right now, no.
Okay. Do you recall
That's a
ever
little
being
petty.
sent
You're better than
texts
that.
like getting fired will make you a cool kid? Eric, go to Brinkman 203. Brickman 203, and this is exhibit.
Yeah, the Bush stuff is weak. He doesn't have a way to connect it, or he hasn't connected it yet. It's just insinuation, which is. And this Cool Kids Club. I mean, come on.
Okay, do you see the text there I'm referring to? Being fired will make you a cool kid.
Mr. Busby, I see that, but I don't know if am I on that exchange? The message at the top, if someone could highlight that. I do have my glasses on, but I'm trying to see it. Yeah, I don't see my name there. I don't think I was on that exchange,
think so?
sir. No, after I left, I don't think so.
Now, when did you find out about the second referral? When did you finally find out?
All right, that was a
when
miss.
I went to the FBI and I
That was a miss.
telling them that this guy was subpoenaing documents that had nothing to do with the referral. When did you find out that the
I've done that
documents
once
that were
before,
being
too.
subpoenaed actually had
Where I thought I
everything to
had
do with the
something,
second
and then
referral?
I
When
tried
did
to
you find that out?
basically impeach the witness on
Mr. Busby,
something, and
sitting
it
here
didn't
today,
have what I had.
I don't recall
Yeah,
when.
that's not
Let's
something
look
I meant.
at same exhibit, Brickman
I've done
202.
that. Yeah. You go up
Y'all
with
read
what you
about it
think
in
is
the
this
news,
devastating
didn't
evidence,
you?
and it doesn't say what you thought it said the first time. Yeah, that's fun.
Again, sir, I don't think I'm on this text message.
Okay, well, just look at the text message I'm referring to. This is about alleged second complaint. Interesting. You see that language?
Could you highlight it for me, please?
Eric could.
Eric.
See that language? They're referring to a news article, and they're for the first time learning that, in fact, Mr. Kamek had been sent a second referral directly from the DA's office, and that's what the subpoena regarded. Is that about the time you learned about this?
Again, I don't have a memory of learning it from that.
I mean, you guys were alarmed, you said. I think the word you used was, we were alarmed that this kid, as you called him, had sent a subpoena to a bank, and you believe that subpoena had nothing whatsoever to do with whether the FBI had violated Mr. Paul's rights.
Do you have the second referral?
You're going to see it in a minute.
What did it relate to? That may help me.
Just a second. I'm going to help you. Don't worry. I'm not going to.
No, my objection is, Your Honor, he's twice, maybe 7 times, I've resisted objecting because the witness, quite frankly, is handling him so well. However, he's now cross-examined him about an email that he's not, or text messages he's not on. He doesn't know anything about. Now he's going to cross-examine him about a second referral, which the testimony is clear he never saw and doesn't know. He's therefore asking, give it to me, and before you ask me questions about it. So I object to him being asked about documents he knows not only nothing about, but is not part of.
That's fair.
I'm trying to find out what was in his mind when he resigned and when he went to the FBI about what he didn't know. And I'm asking him about why the alarm. And the alarm is, Your Honor, I think he's told us that he didn't know about the second referral. And I'm trying to figure out when he learned about it.
I think the law is clear. He shouldn't be questioned about documents that he has not seen in this situation, knows nothing about. I mean, he just said, I never saw the second referral. I don't know anything about it. And now he wants to sort of lead him through, as he gets to do on cross, about things having to do with documents he hasn't seen. So I object to that being inappropriate.
Sustained.
And that's the whole point. You didn't know about the second referral, did you?
I did not.
Right. And so you went to the FBI thinking this kid,
What incredible class.
you called him, should not
This
be
guy is
subpoenaing
so good.
banks.
This guy is so
I
good.
did think that.
But
He lost the
that if he
objection.
was
It was
charged
sustained,
by the
and he
DA's office
just
of Travis
moved
County
on
to investigate
like nothing
bid
happened.
rigging, that would be,
Oh,
in
my
fact, something
God.
that he might subpoena, right?
I actually don't know.
That is so,
I do
that
not.
is such discipline.
And since we're
Oh, his
on the
estimation went up another notch in my book. That is so hard.
You know now that
You
we're
go
too-
there, you have your statement, you have your thing. The
think
judge
I know
overrules
that
you,
because
and you
I've
just
reviewed
move on
the
like you thought that was going to
internal report
happen.
at one time.
I wanted that to happen, and you just move on in a completely seamless way, like nothing happened. Dude, such a poker face. Holy shit, this guy's a pro.
Let's look at the first referral. First referral is you're going to have to get into Exhibit 127, Exhibit 3, as quickly as we can. This document is in evidence.
Rusty wins, and it doesn't matter.
I'd ask you to take a look at it once Eric gets it on our screen.
Wow, I'm impressed. He doesn't fight. He doesn't bitch. He doesn't try to like finagle it back in. He doesn't squirm. He just
Exhibit
moves
3,
on.
Eric, page
Like,
3.
I don't need that anyway. I can move on to something else. I don't care.
All right. Can you see that, sir? He's going to try to bring it up. Page 3, Eric. Bring it up so you can see it.
That's
You
tough.
certainly were aware of this first referral from the Travis County DA's office, correct?
At one time, I became aware of it, yes, sir.
And this was something that Maxwell, Mr. Maxwell, and Mr. Penley were supposed to be handling, true?
That is true.
And Mr. Paxton, the general, did not believe that Mr. Penley was pursuing this matter appropriately. Isn't that true?
He expressed that at some time, yes.
He felt like that Penley who was a former assistant U.S. attorney, and Maxwell, who was a former Texas Ranger, were not taking the referral seriously. Isn't that true?
I don't know if I'd say it that way.
Let me ask you this. If you don't take
And he doesn't ask, how would you say it?
one thing you might do is
He doesn't
not
ask for
even log it
clarification.
into the
He
system,
just
right?
moves on.
Again, I don't know if I would characterize it.
I'll stop gushing over
way
him when
you
he
have.
stops being
Who
this
would
good.
be responsible when a referral is made from the Office of District Attorney, Travis County, to the Attorney General's office to log that referral and open the investigation? Who would be responsible to do that?
I mean, somebody in the division.
Whose division?
Well, it would either be law enforcement or criminal justice. This would be one that sort of both had concurrent.
So ultimately, Mr. Penley or Mr. Maxwell?
No, they were in charge of both of those divisions,
Let's
respectively.
look at Exhibit 5 to Exhibit 127. Did you realize that neither Maxwell nor Penley ever even bothered to open an investigation when they received the referral?
The document you're showing me, I don't see my name on.
We were not able to locate this referral in any of our databases. I want you to tell me, as the first assistant who's responsible for the day-to-day operations of the AG's office, how could it possibly be that when the Travis County DA's office feels like the people they would typically refer this to, that is, maybe the FBI, maybe the Texas Rangers, but she felt that they were conflicted, and so she sends this to the AG's office, why would it possibly be that you guys wouldn't even log it into the system? Help me understand how that possibly could happen.
I would have to ask Mr. Penley or Mr. Maxwell.
I will do that.
I bet you will. I bet
Weren't
will.
you ultimately responsible for making sure that your people did their jobs?
I mean, ultimately, but as I've testified, Mr. Busby, and I'm sure you're aware, it's a large office with a lot of matters, and I entrusted, in this case, Mr. Penley and Mr. Maxwell.
Now, couldn't you see how maybe your boss might be frustrated, who felt, he felt like he was targeted by the feds, right? He expressed that to you before, right?
Is he soliciting hearsay now after all these objections?
Do you have an objection? Are you asking a question or do you have an objection?
I have both. A question on the lead into an objection is, he's asking for hearsay. I guess it must be a valid objection. He made it 30 times when I was talking.
Ooh, snarky at the judge. No.
I'm entitled to ask the man what he's told us multiple times about how Ken Paxton felt about this, that, and the other, and he knows how Ken Paxton feels about the feds. And that's what I'm asking.
Let's just move on, gentlemen.
Tell us how Ken Paxton felt about the feds.
I mean, he did have some distrust of the feds. His primary distrust was the state officials.
So can you understand why your boss might be frustrated with his two top lieutenants when they weren't doing their jobs and investigating the referral from the Travis County DA's office?
I wouldn't characterize that as that, Mr. Busby, at all.
And of course, when you talk about conflicts, I mean,
He doesn't fight
I'm
him.
going to send it to the
It's
Rangers.
like I wouldn't
We're not gonna
characterize it
send
that way. He doesn't fight him. He just
to
moves
the
on.
FBI. But we know that Mr. Penley was a former with the feds,
It's like some expert judo or
He was an
something.
assistant U.S. attorney.
You know, he just uses his own energy just to force him to fail.
Right. And Mr.
know?
Maxwell also had a past history, did he not?
He did, and Mr. Paxton promoted him to the position that he held.
This is like good in a new. This is good in a different way
You
than we've seen.
told us that
This is like,
that you knew
yeah, this is
General
good in like almost a
Paxton
passive
was
way.
frustrated that neither Maxwell
It's a
or
well,
Penley
it's a
would
well,
investigate
it's
the
basically.
referral, right?
I think what makes it particularly
agree with
good
you.
is basically it seems like he has a
Mr.
decision tree
Paxton, General Paxton,
where like
wanted
every
a
possible
outside
outcome
party
he
to do it,
wins.
right?
We
So he
discussed
doesn't
that.
care.
And more than one
Like
person was
everything.
considered
I mean,
as
That's correct.
you know, like a
one of the
goal,
people
but he seems to have like
considered was a man named
accomplished
Joe
it.
Brown.
Yes.
So he doesn't care what the
Joe,
answer is.
I've
He
known
doesn't
Joe
care what
for years.
happens.
him.
It's like,
I've known
yeah,
him
it's
for
just
years and I
it's
like
a
him. Yes,
it's a
had a
decision tree,
favorable
which every possible solution is I
Another
win.
one considered was a man by the name
And
of
so he just
Strickland.
treats it that way. He treats every
Strickland
possible outcome as,
considered
yep, that's what I wanted to have
His
happen.
name
Moving
came
on.
up, yes.
His name
So
came
it's
up,
very
and then
sort
they
of
figured
judo.
out
It's
that
very
Strickland
passive,
was no
using
way
the other
to
guy's
make
energy
$300 an
to
hour,
defeat
right?
himself.
I believe that's true. Yeah.
So instead, they
It's
settled
an
in
interesting
on
style.
A guy who was young.
He's
all
good
he
at
had
it,
to
that's for
do
damn sure.
Was investigate. They settled in on Kamek, right?
Well, eventually, that's apparently what the Attorney General did, yes.
And you actually, even though you claim it wasn't an interview, you spent 15 minutes with Mr. Kamek, did you not?
I spent 15 minutes with Mr. Kamek.
Because we know from the visitor logs, Exhibit 127, Exhibit 6, please put on the screen. We know from the visitor logs, we're going to have to figure out a way to break these out.
And the
Eric?
man definitely does his homework, that's for damn sure. He's got like everything indexed and cross-indexed. He knows exactly where it all is.
We know from the logs, Joseph Brown came to the office on August 27, 2020 at 3:45 and spent 2 hours there, right?
If they can he enlarge that, sir?
Eric, see there at the bottom on Joe Brown, it shows when he came in and when he left. Checked in, checked out. Bring that up. Can you see that?
I guess.
And
I'm not
sorry.
familiar with this document, but
I'm sorry.
yeah, I
May I
understand.
approach the witness, Your Honor?
Yeah, maybe it's easier.
Just wait to go to the mic to speak to him, though. Okay, thank you.
Confirm for me and the members of this jury that Joe Brown on August 27, 2020 spent 2 hours in the AG's office.
I can confirm to you that this document says checked in August 27th, 2020 at 3:45 p.m. And then it says checked out Thursday, August 27, 2020 at 5:45 p.m. And
So he's-
Joe Brown's name is at the top. I'm sorry, sir.
That's all
Joseph
right.
Brown's name is at the top.
Right, that's a visitor log. That's how we know who comes in the office and who leaves the office, right?
I mean, I'll assume that that is true, but I don't know if I've ever seen one of these before.
And let's look at the next page. Here's the visitor log for Brandon Kamek. Do you see that?
I do, sir.
Go to the bottom, Eric. Even I'm having trouble reading that, but it looks like,
What?
just, why don't you tell us what it says? It
Well,
says,
it's cut off on this copy, but it does say August 26, 2020, 3:08 p.m. It says KEDN. We can assume that's checked in. And then it says KED out August 26, 2020 at 4:38.
so would he stay an hour and a half or more in the office?
That's what this document says, yes,
So
sir.
he came in on the 26th, that is Mr. Kamek, stayed an hour and a half, and then Mr. Brown came in the next day and stayed 2 hours. Is that true?
That is correct.
Okay. May I approach the witness?
All right. I'm not exactly sure what we're doing right now. It's sort
And
of
we know,
the plot.
because we have your daily calendar, that you listed in your calendar times and you were considering. You mentioned Cliff Strickland, you mentioned Joe Brown, right?
I did.
If this was so illegal and so out of bounds and so egregious, why the devil are you meeting with these people?
I don't understand the question,
I'm trying to
sir.
figure out why, if you thought, hey, Penley's doing his job, the former AUSA is investigating the feds, the former Texas Ranger is investigating the feds or the magistrates or the DPS, why would you be meeting with several lawyers as outside counsel to do the very same job?
Well, it wasn't to do the very same job.
Well, help me understand then why you met with Joe Brown Why did you think it was just a pleasure call?
No.
Just showed up for 2 hours for no reason?
No, I'm not saying that, sir.
Okay, you knew why he was there. You knew he was being considered for outside counsel to take over the job that Penley wasn't doing, didn't you?
No.
We know from your logs is this Exhibit 127? You didn't put a label on it. The logs. Pull up 127, please.
Yeah.
One moment, Your Honor.
Mr. T says, I see a glowing tan and closet full of camel-colored suits in your future. I'm more of a grays and blues kind of guy, but thanks anyway. Maybe a black on a special occasion. Ancient Ripper says, Damn really knows his evidence and paperwork, that's for sure. Yeah, that just comes from hard work. That's just grease work. And, you know,
Are these
a lot of attorneys don't do it. But he did it.
It's my physical daily calendar, yes.
Is this what you keep on your desk to make
He knows
notes,
exactly
like
where everything is. He has
accomplished
everything
today and some
cross-referenced. He
notes
knows
about
exactly
what
where it
you do?
is that he needs it.
Some, yes, sir.
Okay. Let's go.
He knows the file.
Looking at Board of Managers 558. And Eric, if you don't mind, turn to page 98. It's bait stamped there at the bottom.
I'm not a pinstripe kind of guy. I like a micro dot or like a little bit of texture to help break up the color of the suit.
That document, do we not?
So that's not plain.
You see the name
But
Cliff Strickland?
like a
Yes,
really.
a couple names, but I do see Cliff Strickland, yes.
Yeah,
Okay,
like
can
a-
you tell
like
us
a-
all why
yeah.
you wrote Cliff Strickland's name in your daily calendar?
My guess is General Paxton mentioned him. I know who that is. I knew his father. I know his father.
Sure, and you were supposed to check him out, see what his hourly rate was?
I don't know if that's true. I don't know. I don't
know.
No, I don't know.
Right. But you do know his hourly rate's $800, don't you?
I'm not surprised that it's 800, but I don't know if I know that.
Yeah. That's
$800
too
is-
expensive for outside counsel, is it not?
I would think it's
Yeah, I mean, even this, we have some world-class, probably the world-class lawyers here. They're only getting paid $500 an hour.
Yeah.
You knew that.
Yeah. What's your rate?
Huh?
What's your rate?
Well, you'll find out soon enough. So Cliff Strickland was too expensive for the outside counsel gig. True?
It's a nice little attempt at a burn.
What
What's
I
your rate?
recall is that
I'm guessing it's more than $500 an hour.
denied
But this guy's worth
being
more than
willing to
$500 an hour.
assist in this
So
matter.
So let's go over to page 100 of the same document. He denied doing the work because he wasn't going to get paid his hourly rate. That's the reason. Is that not right?
Again, Mr. Busby, I don't recall that.
Now let's go over to page 100. You wrote
no, you're fine.
some
Stone
other
bleeds.
notes, but you put,
You're fine.
I like Joe. That's Joe
We all make
Brown,
mistakes. We move
right?
on.
I
It's
believe
fine.
that's
Don't
so.
worry about it.
Yeah.
So you had written in your notes Strickland's name, Joe's name. We already know that you met with Kamek for at least 15 minutes, although you've told us all that wasn't really an interview. Why don't you tell us why you're doing this? If you were so adamant we weren't going to use outside counsel and you thought it was wrong and you had all these objections to it. Tell us why you were going through the motions here.
I wasn't going through the motions. If you'll look at the notes below, sir, after I met with Mr. Brown, I met with Mr. Penley, and you'll see in parentheses it says DM out. That's referring to David Maxwell. The outside counsel we were looking at was to assist Mr. Penley and Mr. Maxwell. That was always my understanding. That was always my expectation.
Right, but see, Mr. Penley and Mr. Maxwell weren't doing anything.
See, I disagree with that, sir.
They didn't even open a file.
They kept asking Mr. Paul and his attorneys for documents, and they wouldn't give them documents.
Did they open a file?
I'll do it for $350.
Again, sir, I don't know. I know that
it for
they were
$350.
working on it because at
Worth
different
every
points
penny.
in time, they told me they were. They had meetings. They met with Mr. Paul. They met with Mr. Wynn. They kept asking for documents. Mr. Penley repeatedly expressed his frustrations that Mr. Paul and his counsel were not cooperating.
You were so against the idea that you told Mr. Vassar to draft a contract.
I don't believe
right?
I did that, sir.
Well, that's what he says.
Well, I don't believe I did that, sir.
Do you know that he drafted a contract for Mr. Brown and for Mr. Kamek?
I know he drafted one for Kamek, because that was later. You showed that to me this morning. I don't know about Mr. Brown.
One of the things an outside counsel has to disclose is whether he or she has conflicts that would prevent them from taking on an outside matter, right?
That is true, sir.
Let's look at Exhibit 127, Exhibit 8. As he's pulling that page up, you also told Vassar, we need to keep this on as short of a leash as possible. We don't want it running away, right?
That doesn't sound like me.
All right, we'll ask Vassar that when
Do you
he
have
shows up.
that language?
Well, that's what he
doesn't
said in
sound
his interview, but we'll ask him directly.
that language doesn't sound like Jeff Mateer.
So let's look at the correspondence between, now, where in the chain of command, where is Vassar in relation to you?
Let's see, at this time, he is deputy for legal counsel, and he would be a direct report to me. Through assisting me on that would be Mr. Bangert.
Okay, so you would consider him a direct subordinate.
He is a direct subordinate, but specifically on that because Ryan Bangert had been in that position, he worked very closely with him.
So Eric, if you would, in this exhibit, turn to the last page. And we can see Vassar, the email.
In response to colors in court, you want to wear colors that won't distract.
You see that?
You want to wear something that will not.
I don't think
distract.
I'm on this. I've not seen it
So
before.
blues, grays.
I mean, we can see it on the screen. I see it on the screen.
Vassar's your direct.
You want to wear, you want to wear like.
Again, through Bangert. Yes.
He's sending an outside counsel contract draft.
It says, please see attached.
Yeah. And then in response, Mr. Brown lays out some things that might or might not be conflicts to take on the representation. Do you see that?
Let me read it. Can you make that bigger, sir?
Oh, Lord.
Was bigger? What about the first paragraph first? I'm sorry, the first paragraph first, sir. I see in the first paragraph he talks about malpractice insurance.
Right.
Second paragraph, sir.
I knew a judge once who would insist that all the lawyers wear white shirts.
You see what the scope of the work is as you're reading that?
Because he was an old crotchety kind of guy.
That I will fully investigate the circumstances related to the referral received and provide a report related to any potential criminal charges.
There are probably some judges out there who will still insist that women wear dresses and skirts and shit.
The next page, I should say, Eric.
So you just kind of have to suck it up and do it pretty much anything they want.
More correspondence between Vassar and Mr. Brown related to the draft. See that?
Now, where? Isn't that the same email we just saw?
Eric, please go to the first page of the email. There you go.
Okay.
Vassar says the malpractice issue may be one that we can resolve. That's referring to the previous email about malpractice insurance, right? See that?
I see that, sir.
Now, my question to you is, did Vassar, your direct subordinate, tell you, you know what, we're looking at Brown, I'm done a draft contract for Brown, but he doesn't have malpractice insurance. Is that a problem? Did he tell you that?
I don't remember that, sir.
Don't remember it.
I do not.
Can we agree, as of September of 2020, that your subordinate had drafted a contract for Joe Brown and was talking through the scope, et cetera, of the representation?
These documents appear to reflect that, sir.
Let's go to Exhibit 7 within 127, Eric.
But you can kind of see what they're all wearing, right? They're all wearing dark colored suits. It's kind of,
And bring
what
up,
you'd expect.
Eric, if you would, the email from Mr. Vassar to Mr. Kamek on September 4, 2020. Can you see
Mr. Buxby here is bucking the trend by going with like a light taupe. He's a rebel.
At the same time, he was sending a draft contract to Mr. Brown. He was doing the same with Mr. Kamek.
I can read the email. I don't think I was copied on the email, so I'm seeing it here for the first time.
And of course, we had already seen from the other email there was a malpractice insurance issue with Mr. Brown, right?
I saw that Mr. Vassar said it was resolved.
But there was no such issue with Mr. Kamek, was there?
Highlight that, Eric. I'm sorry, Mr. I don't know. I don't see it mentioning malpractice insurance.
Right. So as we looked at these three people, one of them's too expensive, one of them doesn't have malpractice insurance, and the other one's, he's young, but he doesn't really have to do a whole lot. He's just got to do more than Penley, right?
Again, sir, I would not characterize it that way at all.
And let's go to Exhibit 9 within 127. Here, if the jury wants to see the actual contract sent by your subordinate to Mr. Kamek, they can look at this exhibit. You see it there?
What's on the screen right now is a letter. Well, it says Brent Webster at the top.
That's because he had to collect all the emails.
Say that again,
That's
sir.
because he collected all the emails.
Okay, so it says Webster at the top, and it says from Ryan Vassar. It doesn't say who it's to, except it says general.
Right. This was the contract that Vassar wanted to use with both Kamek and Brown, and a copy was provided to the general. Do you see that?
I see what the email says.
Okay. Now, you've told us all that you objected to hiring Kamek, and the reason you objected is because you thought Penley could handle it and said he was handling it, right?
That's part, yes.
And Penley did not want somebody to come in and do it. He said he was going to do it himself, but he was just waiting on documents, right?
That's part, yes.
Okay. And so as the executive approval process went forward, it stopped at Penley, right?
That's my recollection, yes, sir.
Let's look at AG Exhibit 130. And as we're pulling that on the screen, just tell us point blank, how long had Penley been at the office as of this time?
That's a good question, sir.
I hope all of my questions are good.
Some are.
Some, okay.
Cute.
How long had Penley been at the office as of September 2020?
Yeah,
Mere months, right? 8 months at max, right?
I honestly do not have a recollection of when he started. I know when I came in, Adrian McFarland was the deputy. She retired at a point. We recruited We were looking for the position. Mr. Paxton had known Mark, recommended him highly, and so he became, part of our team. How long? A month? I guess ask Mr. Penley.
I will. What we have on the screen is the executive approval memorandum with regard to the outside counsel contract for Mr. Kamek, right?
Can you jump down to the Ray? I'm sorry. If you could go down to I see it's the executive approval memo. I see the list of names. Can I see the
synopsis?
Not one of them is wearing seersucker, though. So I'm just saying. I don't see a single seersucker anywhere in the gallery. Is it because it's after Labor Day?
On this page.
I'm disappointed.
Eric, it's in bold. Ray.
Yeah, I see the Ray, but I'm sorry, and I keep going back and forth because I'm trying to look at it. What I'm not seeing is Kamek referenced. If you say the next pages are Kamek, I'm not going to dispute that, obviously. The document speaks for itself.
Sure. Let's look at the people that approved it. Let me ask you this. None of these people can veto the Attorney General, can they?
None of these people can veto the Attorney General, but our processes were in place to protect him and to protect the agency that you had proper sign-off.
I'm not asking about your processes, your bureaucrat processes. I'm asking about legally. None of these people can veto the Attorney General, can they?
That's a tough question for me to answer.
Why? You should know that, should you not? If you're the first assistant, that's something you should absolutely know by now, right? None of these people have the legal authority to veto the Attorney General. Isn't that true?
I think if the Attorney General is taking an action that is improper, then it's incumbent on the staff, and that's why these processes are in place.
Improper according to...
So I don't think it's proper, for instance, that Dan Morales goes out and enters into a deal.
I'm not talking about
Greg
Dan
Abbott
Morales.
went out and entered into a deal. The process, it's the agency, and the agency has, I know you're making comments about the process and bureaucratic, and look, it may be, but there's a reason.
It is.
There's a reason. The Attorney General can't on his own go out, because when this legislature, they give authority for the agency to act.
He can't?
You can do a certain thing. For instance, in the government code, one of the provisions in the government code, Mr. Busby, I'm sorry.
You're not answering my question.
Well, I am answering your question.
Okay,
One of the in the government code, the legislature has given the Office of Attorney General the authority to enter into outside counsel contracts. That's authority given. In addition, this legislature gives money so that you have money to actually, so you need money and you need authority. And so when you ask the question, could an Attorney General do that? He needs to have authority and there has to be funds to do it. These processes are in place.
You finished?
I was trying to answer your question.
You're telling the members of this jury, each of them, a senator elected by the people, that a bureaucrat in the office has the authority to veto the boss. That's what you're trying to suggest to us, are you not?
What I'm trying, can I answer your question? What I'm trying to suggest to you is this legislature gives authority to the agency. They say what the agency can do. We have the Constitution, we have the statutes. Part of that is also money.
The Attorney General is responsible for the policies and the procedures of the office. Is that right?
The Attorney General is responsible for the policies and the procedures in the office.
He makes the policies and procedures for his own office, does he not?
He at one point approved those. I think these policies and procedures were in place before he became Attorney General.
They were put in place by Greg Abbott. They're policies and procedures created by the holder of the office. They can be modified and changed by the office holder however she or he sees fit. Isn't that true?
I think that's true.
Okay. But here you are telling us all, or trying to suggest to us all, that the Attorney General, the elected Attorney General of the state of Texas, has to get the approval of his staff to enter an outside contract. That's what you're saying, is it not?
What I'm saying is, in addition to having the legislature also sets the parameters of that authority. Part of the job is
you're losing a little
to
bit.
make sure
You're letting
the
him-
office
you're
is
letting him fight you.
following what the legislature has granted.
In fact, let's see, we know on the first page that Leslie French, the general counsel, she signed off, true?
I see that, yes, sir.
Joshua Godby, he signed off, true?
True?
Ryan Vassar, who wrote the contract, he signed off, right?
Yes.
Michelle Price, the comptroller, that's the woman in charge of the money, she signed off, right?
Yes.
It stopped with Mr. Penley, right?
That is true.
And this outside counsel contract was being done to do the job that Mr. Penley was supposed to be doing. Isn't that true?
You keep asking me that question, and I keep telling you I don't have that same view.
Sure. And let's go to, Eric, if we could, page 14011 of the same document. It's the signature page.
The answer is so obviously
14011.
that the Attorney General has all the power. It's so obviously he has
Here's
power.
the signature page, true?
That appears to be the signature page.
Contract is written where the Attorney General is to sign. Is that right?
Well, what it says, sir, is Attorney General or designee, and I think I said on my direct examination, it was very rare that the Attorney General himself actually signed contracts. Sure. In fact, when the Attorney General did sign a contract, we actually had a special folder envelope that you'd put it in. There were some requirements of some contracts. I think they were things from the feds that they required actually the actual signature of the Attorney General.
Right. There are some things that the Attorney General could not designate. Can you let me finish, please?
Yeah, I apologize. Yes.
There's some things that he had to sign, right?
There were a few things he had to sign. Usually, I think they were federal requirements.
And most of the time, though, he designated someone to sign on his behalf, right?
Well, again, most of the time, in my experience as first assistant, it was the first assistant.
That does not mean he cannot sign, does it? Does it?
No.
Okay.
Wow. Basic principles of agency like 101.
Had a real problem with hiring Hammock. True?
Basic principles of agency 101. I mean, this is dead simple shit, right?
So Penley refused to sign off, and that stopped the process.
The agent
right?
works for the principal. The agent gets their power from the principal. The principal does not lose their power by giving it to the agent.
Are you telling me you did not know that Vassar had drafted a contract?
Yeah.
Is that what you're trying to tell us?
What I'm trying to tell you is the best of my recollection, and the best of the recollection is I don't recall that. No, sir.
Certainly, at some point you knew.
This would be like me as channel owner. I have delegated authority to my mods to mod,
right?
and they can
I knew that they were
overrule me
entertaining
as to
the fact
moderation
of a contract.
decisions.
So I would assume, yes.
Sure.
Eric, Exhibit 127, Exhibit 34 within that document, please.
I'm a mod for Uncivil. I have power to moderate, and I don't think Uncivil is doing it the right way. So I'm trying not to let Uncivil do this because I'm a moderator and he delegated me power. And usually he lets me make the decisions as to who to time out and stuff. So Uncivil usually lets me do that, so I don't have the power to do it myself. He doesn't have the power to do it.
All right.
Because usually it's me.
Looking at Exhibit 34 within one.
Shout out to my mods. We love you.
We see here kind of the DocuSign history. True?
If that's what you say, I don't dispute that. It says DocuSign. They just highlighted that.
One of the good things about DocuSign is you can see exactly when somebody viewed the document. You can see if somebody rejects the document. You can see when they sign the document. Would you agree with that?
I'm seeing this for the first time.
It's common sense, though, is it not?
The document says that. Well, I
don't believe
think
so,
we
sir.
both agreed. Neither of us are tech people. I mean, Eric is highlighting, and I see what that says.
So let's look at Penley's history. Mr. Penley, according to DocuSign and the document that's in evidence, it was sent to him. That is, the CAMIC contract was sent to him on September 16th, 2020. Do you see that?
You're going to have to enlarge it for me, sir.
September 16th, 2020, he was sent the document. True?
Yeah, it looks like it's 6:43:14 p.m. Is that what you're referring to?
He didn't view the document until the day y'all sent the text, did he?
I think there's a record. I mean, that's what this says, but I know there was an exhibit that he sends an email on September 24th that he attaches or tries to attach the DocuSign. And of course, you can't attach one. It was just the fact that one had been sent to him.
Shows us here that he declined the document at 3:03 p.m. on October 1st. And then he viewed it after he had declined it an hour later. Isn't that what that shows?
The document says what it says. I don't have any knowledge.
And when your position is, I was adamantly against the Attorney General hiring CAMIC, right?
I believe Mr. CAMIC did not have the type of experience necessary to assist Mr. Penley in the investigation. You compare him to someone like Joe Brown, who had been a U.S. attorney, who had been actually a DA. I mean, there's no comparison in experience.
Could he issue subpoenas? Could he get subpoenas issued?
Could who? Mr.
CAMIC?
Brown?
Mr. CAMIC.
Well,
Did he have the wherewithal to get subpoenas issued?
Well, we know that he eventually did with assistance from Mr. Paul's lawyer.
Do you know how those subpoenas were actually? I don't want to talk about what you might have read in the paper. I want to ask you about what you know. Do you know how Mr. CAMIC
I haven't.
Can you let me finish?
Well, you asked me a question.
I'm getting ready to
about
finish
the paper.
Just a second, sir. Do you know specifically how Mr. CAMIC got subpoenas issued? Do you know how that process worked?
I do not.
You claimed to the FBI that he appeared in front of the grand jury, didn't you? That's what you told the FBI, didn't you?
I don't think I told that to the FBI.
What we know happened instead is he was assisted by the Travis County DA's office and was sent a subpoena draft with a DocuSign that he DocuSigned.
I think that's a better question directed at the Travis County DA's office, Ms. Moore.
Did you ever bother even to ask how the subpoenas Mr. CAMIC sent were issued?
I didn't because I didn't need to.
Y'all were drafting collectively, you and the other employees or ex-employees were drafting a letter to send to the FBI or the Texas Rangers?
Do you have something to show me?
Do you not recall drafting a letter where y'all were sending drafts back and forth amongst yourselves of a correspondence you were going to send to the authorities?
If you have something to show me, that may refresh my memory.
Well, first, can you answer the question of do you recall it?
Let's look at Exhibit 22, please, within the same Exhibit 127.
It's okay not to recall every document you've ever worked on or something. No would be a fine answer, by the way. Just be like, no, I don't recall that. You know? It was like, well, if you have something to show me, just answer the question. Do you remember or not? You know?
Go to...
Lord.
Page, the pages aren't numbered, but go to number 4 within the document, please, Eric.
Jay Leibgott in chat asks, what do we think so far? Warranted trial or political witch hunt?
It's very difficult to point this out, but it's the sentence starts, the subpoenas sought
kind of too early to tell.
That involve financial records of banks. Bring that. Number 4, Eric.
Kind of too early to tell. I need more information.
I'm sorry, Eric. It's you're 2 pages off. There we go.
I'd like to hear from a few more witnesses. But right now I'm trapped with this guy. Who, like, I'm ready to move on from this guy and hear someone else. It's like, okay, you know,
the last page of the document.
You've had your time on the witness stand. I'm done with you. Can we move on to somebody else, please? That's how I feel right about now, to be honest. Can I turn my volume down? I'm so much louder than the court. Well, only when I'm talking, right? Only when I'm talking I'm louder than the court. That's by design. Hopefully otherwise it's balanced. Because it's designed to duck the court's audio when I'm talking so that my voice will be clearer. Because if I didn't do that and they were the same volume, it would be too muddled.
The Senate starts. I mean, this is something that you guys were collectively drafting, is it not?
I don't know if I've ever seen this, Mr. Busby.
We took it off your computer.
Yeah, so that's by design.
Well,
That's what's supposed to happen.
There were multiple drafts that y'all were sitting around.
Was it Jeff Mateer's computer? Can you show me that?
Well,
It said at the beginning, you've been jumping around. This is one of the disadvantages.
I know, I'm at disadvantage too because my guy's way over there.
I know, I understand. We both are frustrated with it.
Let me just focus your attention on some language of a draft letter, and then you can tell me whether you wrote it.
Pardon me, everyone. My objection is he doesn't know the source of this. He doesn't believe where it came from. It's totally inappropriate for him to be asked questions about it. To Mr. Busby shows what he came from, so he's satisfied it's something that he knows something about.
I can handle that, Your Honor. Sure.
Can you help straighten that out?
Yes, sir. No doubt. Did you realize that Ryan Banger, on your behalf of all of you so-called whistleblowers, was drafting a letter to be sent to either the FBI or the Rangers?
I don't have memory of that.
Did he share with you any of the drafts that he created that was ultimately sent to the authorities?
This is very...
You don't remember?
I don't remember, sir.
Okay, let me just see if your recollection of the things that were going on. Would you agree with the statement that nothing in the subpoenas sought information that related to the allegations contained in the Travis County complaint, which involved potential criminal conduct by employees of state and federal?
This related to the first one?
Yeah.
Yeah. I mean, again, you're reading from this document.
Yeah. I'm just trying to...
I mean, I would ask, again, what I would ask is what you will do. I assume I would ask Mr. Banger, because I don't recall.
I'm trying to figure out what y'all thought you knew.
Pardon me again. This entire line, Your Honor, is so misleading. If I'm right, and I'll be corrected, I'll be glad to be corrected from wrong. I believe what we have here is an excerpt from the 50-something page OAG report. What this is a self-serving version of their report that he's being asked about, as if it's something that first that he wrote, and if not, then something that was written by someone else. And he's acting like this was a fact that they did something. He needs to disclose to this witness where this comes from. It's not coming from his computer. He doesn't have any knowledge whether it's coming from anyone else's computer. This entire line is unfair and wrong for the witness. If he tells him where it's coming from and then ask him if it's right, I won't object. But this kind of shooting in the dark is inappropriate.
Your Honor, Mr. Hardin, if he looked at the document, would know that this came from Ryan Banger's computer, that it was a letter that he was drafting on behalf of all of the so-called whistleblowers. And there are things in the letter that I think is a misconception that they all had collectively, which was they didn't know about the second referral. That's why I'm asking these questions.
And I've said that, Mr. Busby.
Okay. And that's alarmed you. He sending subpoenas to banks, and it has nothing to do with the first referral, right?
It was one of the things that alarmed us, I think I've said.
All right, I now have a short for my clip that I did earlier, so I can upload it to Shorts.
For a predicate for these questions, Your Honor, is this document that he's been asking him from the Attorney General's office's self-serving document they published to the world as to their version of events? If that's where it's from, then I can go to the page of that report and determine that. But this witness needs to know that's what it is, rather than suggesting it came from his computer or somebody else's computer. This did not, I would respectfully suggest.
It's taken up my time, and if he read the documents that's in evidence, this document is in evidence, he knows that it came directly from Ryan Bangert's computer.
He doesn't
and he
know
knows that
thing.
Please. He knows that Ryan Bangert circulated this so they could get their facts right before they sent this correspondence to the authorities. And that's all I ask him is this true that none of you knew about the second referral, and that's why you're all so upset? That's the point. And I think the point's been made.
Let's move on.
Okay.
Your Honor, this document, it looks like this document was prepared by Mr. Brent Webster.
No, geez, come on. You need to look closely at the document. It's very clear, prepared by Ryan Bangert. Now.
All right. It looks like.
Are you satisfied now?
It looks like it's two other people, but it is not this man.
Your Honor, I made that clear. It's Ryan Bangert. I've said it 3 times.
Excuse me. You've testified repeatedly, Mr. Busby, that this man knows X. The only way you're going to know what he knows is to ask him questions rather than suggest it was done by somebody else.
Which is
so
what I was.
I'm objecting those improper predicate for
Counselors.
this question.
Okay. Let's just move on.
Sure.
Thank you.
Trying to. Now.
The school kids are not playing nice with each other right now.
Do you know who Bailey Molnar is?
Say that again, sir.
Sorry. Do you know who Bailey Molnar is?
Spell my last name.
Molnar. Works at the Travis County District Attorney's Office. I don't want to say she's a clerk, but she does administrative type work.
I don't think I do. Excuse me, sir. I don't think I do.
So you wouldn't have any role in her assistance with Kamek in issuing subpoenas?
No.
Now, you had asked, and your lawyer, or the House's lawyer.
Come on, TikTok, post it. Post it. Post you, damn it. Post you, TikTok.
I've never seen it.
If you show it to me, I guess.
Sometimes TikTok does not want to play nice with me. Post.
13.
Post. Damn it. Post. Post.
Okay. Have you seen this document before?
I'm still reading it, sir. Thank you.
Have you had a chance to read it?
I'm sorry, I don't read. I read fast.
My brother used to cover my ears at night. I now know the disgusting reason why. I thought it was normal that my brother...
Goddamn TikTok.
That helps. Thank you, Eric.
What we have on the screen here is what has been referred to as the second referral. Would you confirm with me that this document, this referral, was sent from the DA's office of Travis County directly to Mr. Kamek in Houston, Texas on September 23, 2020?
Well, what I confirm is it's dated September 23rd. The address that's listed is
Victory!
the office of the Attorney General of Texas.
Do
you know who Don Clemmer is?
Don Clemmer, I do know who Don Clemmer is.
Who is Don Clemmer?
He used to work at the Office of Attorney General before I was there.
Okay.
I believe worked with Adrian McFarland. Actually, he might have been in a deputy position at one time for when Governor Abbott was General Abbott.
I'm asking, okay, sir, do you see how he listens?
Trying to answer your question.
I
I'm
understand
sorry.
what you're doing. Can you tell me and confirm that at or around September 2020, he worked at the DA's office for Travis County?
I know he worked at the DA's office. I don't know what his position was, but I see that a letter says what his position is.
Yeah, it says Director, Special Prosecutions Division. See that?
I do see that, yes, sir.
And you told us that Clemmer used to work at the AG's office, right?
Before my time, yes.
Right, so you know that the AG's
For those
office
of you
is
who
not
don't,
protected.
for those of you who have TikTok and haven't subscribed to my TikTok,
He would know.
I'm trying to
that
get
the
past
Office of Attorney
1,000
General is not
subs.
in Houston, Texas, right?
Well, no, we do have an office
So,
in Houston.
if you want to help
We
with
actually have
that, that'd be
several
good.
offices. I just know that.
Because once I have 1,000
not
subs, I
one
can start
office.
live streaming to TikTok. That sounds
You would
hilarious.
know.
Well, you'd have
So,
to, honestly, you're asking
if you
me
could
a
help with
question
that, that'd be
you know.
great.
I don't know.
I've
the
got
answer to, but
904.
He would know the answer.
So I need 94 more. We're making progress.
So rather than sending the referral to Penley or Maxwell, the second referral was sent directly to the outside counsel, Brandon Kamick, right?
This letter says that. I don't know why that was done.
And you had no idea about this referral until sometime well after this, isn't that right?
Yeah. Some of you say I need to dance or post like scan or something. I post legal shorts. I post shorts about cases and law and stuff. I'm not sure if I'm doing the TikTok right, but I got 904 followers.
Now, who is Lisa Tanner?
Lisa Tanner was it may still be. Lisa Tanner was a prosecutor at the time. I was there in the criminal division. You want more? She's one of the key prosecutors for the state of Texas, or was.
Now, on did you ever once? Let me ask it this way: did you ever discuss with Mr. Clemmer outside counsel for the AG's office?
I don't know if I've ever met Mr. Clemmer.
Okay, I'm not asking that. I'm asking whether
To the 600 of you currently watching, by the way, thank you for being here.
Mr. Clemmer.
Appreciate all of you who are
I
here.
had a discussion with Mr. Clemmer.
If you haven't hit the subscribe button, by the way, if I could just ask you to make sure that hits the subscribe button.
You know
we
what
really
the
do
subject
appreciate
was
everyone who
of
shows support of the channel.
The
And I'm hoping I'm
referral.
bringing to you some high quality
you know what
content.
Mr.
So,
Paul was alleging?
please hit subscribe.
You have to show it to me.
Thanks.
Do we have the second one?
I'm glad 650 of you are with me. That's very awesome. I appreciate it.
This is
It makes me
evidence?
happy. I'll do a little happy dance.
I'm going to offer into evidence House 168. It's the second criminal complaint filed by Nate Paul.
Any objection?
No objection.
Entered into evidence?
We don't have a hard copy? No. All right. Eric, go to the second page, please. Next page, please. Go to page 6. All right. And the jury, to the extent they want to look at it, can see in Exhibit House 168 the nature of Nate Paul's complaints. And you didn't know anything about this. That's what you told us.
If you want me to, I
I don't want to waste a lot of time on it. I just want to make sure the jurors know that there is a second referral, and it was the genesis of it was Nate Paul complained to the Travis County DA's office.
I mean, if that's what you're saying, obviously the document is what it is. I'm not, absent me sitting and reading it, I'm not able to answer.
Now, you told me, I think, that if you're going to hire outside counsel at the AG's office, you need
Yeah,
to
the
go through
lawyer's still very good. He's getting a little bit lost in the minutia, but he's still very practiced.
It's absolutely essential that if when you talked about the legislature and the money and the codes and the policy.
It's nice to know he's still human at the end of the day.
If you're going to,
that's validating.
You are going to hire, that is, the AG's office is going to hire outside counsel, right?
Yes.
That's
actually hire and execute a contract. You have to go through the process.
Right, and that includes getting approval from the comptroller in that process to fund it, doesn't it?
That you have to have money that the legislature has allocated.
And you told us, I think...
Someone asked for a short summary of who this guy is. This guy was the principal assistant to the Attorney General. I think he was number 2 in the Attorney General's office, but don't quote me on that, but that's where the impression I get.
So things are done above board.
And was working for Paxton and observed things that caused him concern relating to Paxton's apparent helping of this guy named Paul.
Exhibit
and he resigned in protest, essentially. Went to the FBI, complained, so forth and so on. And so he's here. His value as a witness is to testify about the things that Paxton did to potentially benefit Paul that were out of the norm.
Together. Given what you told us,
so that's kind of who this guy is.
Attorney General and hiring Mr.
And at the moment, we seem to be like a little bit in the weeds on some of the details.
Email from you,
which you know. Okay, but it's not the fiery brand we were earlier today.
To Lacey Mays, where you authorized the use of $50,000 for outside counsel.
I think basically what he's trying to show at this point
what I was talking
is,
about, exactly.
and what he's trying to show at this point is that this guy was not aware of the facts, and he acted in a way that was not based on reality.
Johnny Sutton. Wait, in order to do that, can I complete my answer?
Yeah, sure. Go ahead.
In order,
I'm not necessarily sure.
You have to have funds set aside. You can't just enter into a contract.
This is the best place to do that. It might be better to do it by calling one of your own witnesses rather than trying to cross this, because you're trying to cross this guy on things he doesn't know, which is sort of a weird, which is kind of a weird proposition, right? You're trying to be like, you didn't know about this, you didn't know about this, you didn't know about this, you didn't know this document. So you're trying to cross him on things that he explicitly doesn't know, which is a slightly weird posture. So I'm not sure this is necessarily the optimal way to go about it, but
I know you don't.
That's what we're trying to do, basically.
You're sending an email to Lacey Mays authorizing $50,000 of our taxpayers' money for an outside counsel, Johnny Sutton. Is that right?
That
and then Tony raises the possibility that this is all actually legwork for some future thing that hasn't materialized yet, which is a fair point, Tony. Well observed, right? That this isn't paying off now, but will pay off at some later time, which very well may. That's a fair point. Well observed.
Johnny Sutton is my personal lawyer.
Is he sitting right over there?
Yep, I see him.
Okay. You tell me what authority you had as first assistant to set aside our taxpayer money to hire an outside counsel. You tell me that.
I had the authority to set aside the funds because the next step in the process would have been to go through the executive approval memo process. And if all of the deputies would have signed off on it and we had made the determination that that was in the best interest of the state to retain Mr. Sutton as counsel.
For who?
For the state.
For what?
Because we were looking into potential crimes that were being committed.
Did you tell your boss that you were allocating $50K for an outside counsel contract?
If he had come to the meeting on can I finish? Are you done?
Yeah, I know you're getting excited. Just let me
Well,
finish.
I am, because this is...
Take it easy.
You're trying to misstate things.
Please.
Let's
Did you
settle
tell-
down here. Just answer the question.
I'm sorry, Mr. President.
You know we had to find this forensically? Did you know that?
No, I don't know why. I turned in my computer.
I don't know why either. But let's be clear about what you did. About what you did. The loyal servant, trusted friend.
Yeah, I never got to answer the question.
I'm going to ask it.
Yes and ask. Just wait for the question.
What authority did
My
you...
objection is, if you'll quit the commercials and testify and just ask the question, I don't have it. But when he puts all these kind of accolades in there, that he is usually making fun of the witness in his question, I strenuously object. He can ask a simple question, but not with all these commercials from his side of the case.
What's the objection?
My objection is that he has no foundation and basis for asking questions. He is simply harassing the witness by putting a lot of adjectives in there that he thinks serve.
Harassing the witness.
He has for about 2 hours testified, and I've been very patient about it.
It's cross-examination.
They are not questions. That particular one, if we read back, he starts going on all of these little commercials for his point of view, and I object.
That's
Again.
Let's just
of
move on.
what cross kind of looks like a little bit.
What authority did you have to secretly go behind your boss's back and allocate $50,000 for outside counsel contract? What authority? Who gave you that authority?
I can't answer that question because what you've said is absolutely incorrect.
Show me a
First
statute.
off, sir, we asked to meet with the Attorney General on this date. If we'd had a meeting, had he been here, we could have had a discussion. And perhaps Mr. Sutton could have assisted even him at this point.
Let's look at AG Exhibit 361. And go to page 7, Eric. Lacey Mays took your
What authority did you have?
and sent it
Well,
to
that's not a fair
Comptroller, right?
characterization. Blah, 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 blah.
I mean, this is part of an email. I don't see the first part of it. Again, I don't think I'm copied on it.
For a rule of law guy, he does seem to be bending the rules a little bit. You know, taking the AG's name off the letterhead,
From the screen.
authorizing expenditures of funds for outside
I
counsel.
don't even understand the objection. This is in evidence.
He's saying it's not in evidence. He's saying it's not in evidence.
Deciding that he'd
it
void
is in
contracts signed by the
We offered it in
AG.
evidence, and if to the extent that he doesn't know that, we'll offer it again.
Can we see the exhibit number, please?
AG
It's
361.
361. Yeah, okay.
Do you object?
Yeah, no pants, baby. Bureaucrat gonna bureaucrat. I was unhappy because the AG,
All right, so
politically elected,
Your Honor,
was interfering
this
with
is
my
not one
ability
of
as a
those that
bureaucrat
you
to,
read.
you know,
It was
bureaucrat.
provided to us this morning, an amendment to their list, and I don't even think we still have a copy of it, the physical copy of it, and it's not an exhibit that was part of the agreement everybody reached overnight. So the problem is, we don't have a copy of this.
Joshua, that was a fun
Copy.
clip, wasn't it, that I posted? That was a fun clip of 3 minutes of pain. Yeah.
It's now been up on the computer as an inadmissible piece of evidence for about 5 minutes.
Yes.
if the AG is trying to make the argument that these people essentially were fired because they were trying to stage a coup against him, he's on his way, right? It's like, I didn't fire them for the whistleblowing. I fired them because they tried to stage a coup against me, which is basically what they argued in their opening,
we'll take it down
at least
until
partially.
we resolve this. Just take it down for a moment.
And it's like, yeah, so you're trying to like go around the AG,
Well, we're going to object. And
trying to do things on your own,
later.
trying to interfere with
This
the
is
AG,
actually
trying to
an
prevent
excerpt
them
from
from
a
doing
forensic
things.
report that we've never had disclosed to her. It's never been part of.
So basically, you tried to stage a coup
Quite
because
frankly, the
best interest in
generated-
Texas. Because you see, the thing is, the Attorney General doesn't have power.
2021.
The Attorney General only has power to do things that are in the best interest of Texas. And I, first assistant over here, in my judgment, felt that he was not acting in the best interest of Texas. Therefore, his power was ultra vires. And I was empowered to do things because the office of the AG was vacant.
That's the way the process is supposed to work. And we do object. It's a
Someone asked, what's the difference between whistleblowing and a coup? Whistleblowing is where you report what happened. Coup is where you basically try to undermine them from doing stuff.
We got this, we're told, from them. We got this document from them. I mean, I would have mentioned that, Your Honor, if I'd have known it, but I was just told that in my ear. And of course, it's emails between people in the office, including this man here.
I don't think I'm on that email, sir.
The witness, just hold for a moment.
That was a question.
Is it your document, Counselor, from you all?
I can tell you that we, the trial team, have never seen this document and never knew that it was going to be proposed as an exhibit. I will, when you say that they got it from us, I don't know how they got it from us unless the Attorney General, this is produced by the Attorney General's office. These are not produced by us. I don't know, we'd have to look during the break. We can try to do that because I think that's upcoming. I will be glad to inform the court if it turns out that this document was given to us. We will tell you that, but that is still not the way admissibility should be. If they're going to offer an expert report in any kind of, this should have been disclosed a long time ago.
It's a good time to take a 10-minute break. We've been here for 90 minutes, and you can take a look at it. Thank you.
Thank you, Judge.
Yeah. All right. Well, people. So, yeah, I think what we're trying to do is effectively tease the fact that this guy was fired for cause is basically what we're trying to do. This is Paxton's idea that seems to be developed in their opening, and they promised a lot in their opening. So I'm expecting quite a lot from the defense case because, you know, there's no particular burden on the defense, but then once you sort of put it on yourself, you know, you have to fulfill your own obligations. So the defense can sit there like a bump on a log, but the moment the defense opens their face hole and starts making promises, boy, they better pay off, right? So this is why you don't open your face hole until you're ready to go, because you got to pay it off. So they're making some representations, and they seem to be teasing that along these lines, that Paxton fired these guys for cause. Namely, that they were trying to subvert his authority, go around him, prevent him from doing his job, taking his name off the letterhead, apparently trying to set aside money that was sent to the office, and so forth and so on. Crystal says Hogue just posted his first H&H stream post-recovery. I don't think it's his first, Kestrel. He had one, I think, some time ago where he came back. But either way, I'm glad to hear that Hogue is doing well. Richard Hogue, for those of you who might not be familiar, is a creator with the channel Hogue Law, as the name sort of implies, H-O-E-G. Richard Hogue had a stroke. He's basically my age. And so he had a stroke, which of course was unexpected. But fortunately, he's doing very, very well. And basically at this point, it's like the stroke never happened at all. So, you know, that's good news. So he's back and in the saddle and seems to be basically back to where he was before. So that's nice. So we're very happy that he's doing well. Anyways, where was I? So yes, they're trying to tease the guy. They're trying to tease the idea that this guy was acting as part of basically a coup to overthrow the attorney general. Because, well, we're the elected bureaucrats, right? We have the best interests of Texas in heart. We're here, we're the bureaucrats, and we're here. And this guy is just elected to the office of AG. Who does he think he is? So forth and so on. So, yeah. And also apparently is looking at starting a morning news show again, at least on a weekly basis, because he used to do a really early morning show, like 7 my time or something like that. I forget exactly what time it was, but he used to do an early morning show. And is looking at doing a morning show again in the near future, so we may be competing with Richard Hogue for viewers, so we'll see how that goes, I guess. Yeah. And also, he's also the lawyers for Paxton are also trying to get out of this guy that he just didn't have the full knowledge. He didn't have a full picture, and so he acted perhaps hastily. So they're it's like, they're not directly attacking his character, which is fine. It's just basically being like, you saw smoke, but you didn't investigate far enough. Maybe we could work collaboratively with Rick. I don't know. I'll have to ask him about that. I think Rick probably wants to do his own thing, to be honest. So we'll go from there. But it doesn't matter. Tomorrow anyway, we'll be streaming this. So I mean, regardless of what Rick does, we're committed to this. So we're doing that tomorrow. Grant, that's not a question I'm going to answer. We're not doing past drama. Let it go. Let's let it go, guys. Okay, we don't do drama here. I will be streaming tomorrow. I don't have class tomorrow. I decided to stop doing classes. I'll tell you why at a different time. I don't think I want to discuss it publicly. But I made a decision to stop attending classes, so there will be no more classes on Thursday. That isn't necessarily a promise that I'll start streaming on Thursday, because I might need the break, or maybe I'll switch it to Wednesdays or something. But, yeah. Theoretically, I have class tonight, too. I have stand-up comedy class. I don't understand what I'm doing. I have written no material. Stand-up comedy is hard. I decided to take a stand-up comedy class, and they're like, write material, and you can come back and we'll, like, evaluate it. I'm like, but how? And they're like, just write it. And I'm like, eh. So... all right, let's see what else we got. In this book. We read chapter 1. Let's take a look and see what other chapters we've got. Let's see. Shut up. All right. Chapter 2 is entitled Meet the Murdaughs. Chapter 3 is entitled The Legend. Chapter 4 is entitled Attorney Representing Attorney. Chapter 5 is entitled Key Witnesses. Title 6 is entitled Trial by Jury. Title 7 is entitled Judge's Rules. Chapter 8 is entitled Judge's Tragedy. Chapter 9 is entitled The Plan. Chapter 10 is entitled Media Matters, Motions, and Money. Chapter 11 is entitled Media. Welcome to Walterboro. News at 11. Chapter 12 is entitled We the People. Duty, Honor, and Service. Wow. How many chapters can you write? Damn. How many chapters can you write? Chapter 13 is entitled Oh, What a Tangled Web We Weave When We First... Okay, so let me try this again. Oh, what a tangled web we weave when first we practice to deceive. That would be the title of chapter 13. Chapter 14 is entitled Judge Newman Sentencing. Chapter 15 is entitled Actions Speak Louder Than Words. Chapter 16 is entitled Lifelong Friends. Chapter 17 is entitled Escape to Murdaugh Land. Chapter 18 is entitled Curiosity in Colton County. And chapter 19 is entitled Baptism by Fire. Wow. Wow. That is, wow. I mean, all you literally have to do, for those of you who don't know what we're talking about, we're talking about the Murdaugh murder trial from South Carolina. Okay, Murdaugh killed maybe his wife and son and was on trial for the murders and was found guilty. And the clerk of court, the person who, among other things, reads the verdict, wrote an entire book and possibly admitted to witness tampering, or jury tampering. That may lead to a new trial. Fun and exciting. So, yeah, that is entertaining. Yeah. Oh yeah, no. And what's better is because I'm reading it on stream, it's a business expense. So I get to write it off of my taxes. Yep, that's what we're doing. Good times. Which of these chapters pleases you, Sandy? Which of these chapters would you like to hear most? Which of these chapters is best chapter? Yeah. So there are problems. There are problems. Let's read from the sentencing. The last one, you want to read Baptism by Fire? Okay. Chapter 19, Baptism by Fire. And these three men, Shadrach, Meshach, and Abednego, fell down bound into the midst of the burning fiery furnace. Then Nebuchadnezzar the king was astonished, and rose up in haste, and spake, and said unto his counselors, Did not we cast these three men bound into the midst of fire? They answered and said unto the king, True, O king. He answered and said, Lo, I see four men loose, walking in the midst of fire, and they have no hurt. And the form of the fourth is like the Son of God. Then Nebuchadnezzar came to the mouth of the burning fiery furnace, and spake and said, Shadrach, Meshach, and Abednego, ye servants of the Most High God, come forth and come hither. Then Shadrach, Meshach, and Abednego came forth of the midst of fire. Daniel, chapter 3, verses 23 through 26, King James Version. In May 2023, my return to the South Carolina Clerks of Court Conference was akin to someone who had spent a decade or so in the minor leagues as a court reporter and then had a good rookie year in the major leagues as a clerk of court before beginning the thrust into the spotlight during her sophomore year. I had won the clerk of court election in November 2020, and trips to the conference provided pure learning experiences from very seasoned professionals who knew how to run my courtroom. My colleagues greeted me at our Myrtle Beach conference with pet names like Superstar, and some jokingly asked for my autograph. They also told me they had been praying for me, and they were proud of me for handling the trial with such grace. It was wonderful having that acknowledgement from my peers, many of whom provided guidance for the trial of the century, and I truly felt like one of them. It was also a humbling experience for me to meet up with key figures who oversaw the trial. Prior to getting COVID-19 during the week of Valentine's Day 2023, the pressure started to get to me by the third week of the trial. Some of it was physical and some of it was emotional. I felt like everyone wanted a piece of me. The public, the jurors, the judge, the county, finance folks. And I'd never been through a level of scrutiny before for that courtroom trial. On the outside, I was nice and patient as could be, navigating from task to task. But inside, a storm was brewing. A volcano inside me erupted at about 4 a.m. on February the 7th, and I took out my frustrations on one of the finest and most knowledgeable financial folks.
Still not back, so we'll wait a moment.
He is truly an asset to Colton County and has been most helpful for the clerk's office. I remember trying to explain to him how I felt my husband, Tommy, in between uncontrollable crying spells. I said to him, I'm 55 years old, and why do I have to answer like a child for things I have to do in my job? Boy, if you think you've had to answer for things like a child before, just you wait. Holy shit. An email had sent me off when questioned how many meals the county was buying to feed people at lunch during the trial. It's read, can you let me know why we're now getting 40 meals? My limited understanding is that we need to feed those who are not allowed to leave the courthouse, like the juror, the alternates, the defendant, the judge, but I cannot come back to 40. I took it in the worst, sleep-deprived, pressure-packed way. I blasted back via email and addressed it to the Chief Justice in the state of South Carolina, the judge who assigned Judge Newman to the Murdaugh trial, and copied the person who originally questioned me along in a slew of other people.
Colleague, Mr. Hardin, say that these documents had never been produced to us. We haven't seen these documents. Your Honor, the documents are bait stamped with their bait stamp. They sent the documents to us, and then when we sent our exhibit list back to them, it was sent to Mr. Hardin, and I'm told he failed to forward it to the rest of his team. So, you know, I've withstood a few criticisms from Mr. Hardin, which is fine. You know, that's his job. But to suggest that he's never seen the document, that we didn't give him the document, and to object to a document that he gave to us, pretty ridiculous. So we would offer into evidence the two documents that we were discussing before the break, just to confirm, AG 368 and AG 361.
If I may, I told the court that I would look into it, and I think I have it. I think I have the sequence right. This was a document that the AG's office produced to us in August, and in compliance with your order, we tried to turn them around many times within 24 hours, certainly as soon as we could. We produced this document, along with a lot of other documents, back in August, so almost 2 months ago. When we produced it, it was produced in mass, just like this. It was never listed on their exhibit list, and it was never listed as a proposed list. I'm sure Mr. Busby maybe inadvertently spoke now, I'm sure not deliberately, but he didn't add that when they, first time we knew they were going to list it as an exhibit.
All right, people, we're literally having a discovery fight at this point in the middle of the trial. In case you guys want to know what a discovery fight looks like, this is what we're doing. We're having a discovery fight. Who produced what to whom and when on, oh my God.
Where the agency, after these people left, went to all their computers and did a forensic report looking for evidence and things. And in this one, this was a forensic.
Aren't discovery fights fascinating?
Computer of Lacey Mays. And that's the sum total. So he is right in that we produced it to him. He's somewhat misleading in discussing when we got it as an exhibit, and we're on notice it was going to be offered as an exhibit. But now that we've looked at it and all, I'll be glad to waive my objection. We'll be glad to have it be admitted and let the jury look at it and understand what it is.
Thank you.
So that was a very, very long-winded we're cool with the exhibit, which could have been said in many fewer words.
Yes, so
But we needed to have an entire history of the document. We needed to understand how the document started as a lowly little document and rose through the ranks.
Actually, let's just make sure we focus on what this witness sent. Eric, put 368, AG 368.
We could write a book about the document now, because the document has had as much screen time as the Colton County clerk.
Go to the email sent by this witness.
The words I have to say, a document story by document.
Sir, I want to make sure we all understand.
Little did the person know when they first started typing the keys on their keyboard that one day I would be the center of a Texas impeachment trial.
Enlarged it. Can you?
Dot.
So I can. I'm sorry. Can we? The Madam Court Reporter keeps telling me that when I look at the document, I don't speak into the mic, and so I'll try to be deliberate. Yes, it is dated. It looks like, if this date is correct, is October 1st, 2020.
Listen to my question.
Yes.
You sent this email the day after you went to the FBI, isn't that right?
You know, now that I see that date, that time.
When the seed was first planted in the ground, little did my parents, the tree that bore me, knew that I would grow into a tall tree, only to be felled one day to turn into the paper that would form the basis of the document at the Attorney General's office. This is my story. A seed's life, the seed of corruption.
There's no
by seed.
At that time, I'm not disputing that I sent an email.
On that date.
I think that date or the day before, the timing could be somehow screwed up on the computer. I don't know.
Let's make sure we have a clean record and everybody knows what was going on.
Are these jokes working for anybody? Is this thing on?
You reported what
Testing?
you claimed to be crimes. And then you told one of your subordinates to allocate $50,000 for a lawyer. Isn't that right?
To set aside unobligated reserves in the event we did enter into an outside counsel contract, and the we being the agency.
And you did that. This lawyer, Mr. Sutton, who represents you now, was supposed to be helping Ken Paxton some way?
Potentially, we wanted to meet with Mr. Paxton on October 1st.
With a lawyer?
No, it was going to be just the deputies first, but perhaps that could have led to that had he met with us.
Mm-hmm. So you wanted a lawyer to meet with you with the AG? I'm trying to figure out, why are you using state monies for a lawyer for your personal use?
I wasn't, and I didn't, and I wouldn't.
Grant says I'm funny like a lawyer. Well, that's promising. That's good news.
I guess from your point of view, it's okay to step outside of the procedure when you want to hire an outside lawyer, but it's not okay for the elected attorney general to do so. Is that right?
That's absolutely false.
Now, are letters sent by the Attorney General of the state of Texas official documents?
Yes.
They are official documents, are they not?
I believe so.
Let's all be clear. According to the former first assistant, your position is that letters sent from the AG's office are in fact official documents, correct?
They're documents from the office, and they would be, depending on the subject matter, I believe so.
Are you familiar with Texas Penal Code 37.01?
You've got it on the screen.
Let's look at it. Let's bring it up where we can see it, Eric.
By removing the title from the letterhead, he fucked with an official governmental record.
Can we have it bigger, Eric? There we go. Now scroll it where we can read it. Tell me if I get this right. A person violates 37.10A when he knowingly makes a false record in or false alteration of a government record. Did I read that right?
You read the document, yes?
Before I showed it to you and read it to you, were you familiar with that particular provision of the Texas Penal Code?
Sitting here, perhaps, I don't know.
Exhibit 127, Exhibit 19, please, Eric.
I'm not exactly sure that's what the statute has in mind, but you could read it that way. So, yeah.
All right. What we have here is a letter sent on the same day you guys went to the FBI by your subordinate, Mark Penley, correct?
That appears to be a letter September 30th to Mr. Kamek from Mark Penley, correct?
Who altered this government record?
I don't follow you.
I bet you don't.
I don't follow you. I don't think this document was altered.
Do you see the letterhead that this letter was sent from?
I see the seal of the Attorney General on it, yes.
Do you see the Attorney General's name?
I do not.
Who removed it?
I don't know.
Would you ever countenance that?
I'd have to know the circumstances.
Well, these are the circumstances. It's September 2020, and your subordinate is sending a letter, an official letter from the AG's office, and he removes your boss's name. Would you ever countenance that?
Again, we'd have to ask Mr. Penley.
I'm asking, would you ever countenance that?
I don't know in this situation. I don't think this letter was altered because it does have the seal.
Would you authorize that? Would you authorize removing the duly elected Attorney General's name from official correspondence? Would you authorize that?
Again, I don't know if that's required or not.
Would you do it yourself?
I am anticipating that you're going to show me a document.
I am indeed. My question is, would you have done it yourself?
I don't know if Mr. Penley.
Hey, Attorney Tom, good to see you. Hope you're doing well.
I focused on it.
Busby's kicking ass, Attorney Tom. He's kicking ass and taking names.
Yeah. Somebody. This is not
Hey Tom, can you get me an interview with this guy? I'm dead serious. Because I like this guy. I will do an entry-level job. Because this guy's kick-ass. He works in Houston. Can you get me an interview?
Isn't that right?
I don't know.
Because I am not beyond using connections I have. If you have a connection.
30 within 127, Eric.
I was thinking about sending this guy a CV.
Last page. Nope. There you go. Do you see that on the same day you were allocating $50,000 for Johnny Sutton, you were also sending a letter to Brandon Kamek?
I'm going to become a personal injury lawyer, guys. It's kick-ass.
Again, we discussed what we did with regard to Mr. Sutton. I do see that I sent a letter or signed a letter on October 1st, 2020, sent via.
You signed an official correspondence from the Attorney General's office of the state of Texas that had his name removed. Isn't that right?
That's what this shows. I did not focus on that at the time.
Who gave you the authority to do that? Who gave you the authority? Someone that you've already admitted have never run for office, have never gotten a vote, the authority to alter the official letterhead of the Attorney General's office.
I mean, as I mentioned to you, Mr. Busby, I didn't do that. I signed a letter.
Well, who did it in the office? Somebody had to be working for you because you told us you control the day-to-day activities of the office, remember?
I don't know who did it.
And it was just an oversight on your part that you were signing a letter that had your boss's name removed? Is that your testimony to these jurors?
My testimony is that is not something I would have been focused on October 1st.
You were involved in staging a coup, weren't you?
Absolutely not.
That's what you were up to.
Absolutely.
That's the reason you went to the governor's office. That's the reason you were talking to TLR. That's the reason that you had or engaged in conduct removing your boss's name. You were staging a coup, weren't you?
Absolutely not.
He doesn't care about the answer. He laid out everything. He doesn't care about the answer. That's one of those times when you can ask the ultimate question because you don't care what the answer is. If he says yes, great. If he says no, that's fine too.
We saw that you signed off on that, right?
We reviewed documents that I approved the investigation and I approved the intervention, correct, sir?
You remember you talked about you came back from vacation and that you realized, you found out that a legal opinion had been issued. Remember saying all that?
About the foreclosure?
Do you remember saying?
I'm asking for clarification, sir.
Yes, sir.
Is it about the foreclosure letter?
Yes, sir.
Yes, I remember.
You called it a legal opinion, didn't you?
If that's what the record shows, it was a legal opinion. It was done by lawyers, the Office of Attorney General, under, I believe, the Disaster Authority.
Disaster Authority.
Fact.
Disaster Authority.
Put it on the screen, please.
Wow. Okay.
Article 2 of the impeachment articles.
Disaster Authority. I see. Yeah. Woof. Where have we heard that kind of thing before? Where have we heard that kind of thing? A petty bureaucrat stretching language beyond all hope to get what they want. Oof. Yeah, this is disaster, sure.
All right, I just want to, for the sake of clarity, one of the charges in this case is that General Paxton misused his official power to issue written legal opinions under subchapter C, chapter 402 Government Code. Do you see that?
I see what you've read, yes.
Now, let's look at the legal opinion that has been referred to. Go to Exhibit 12741, Eric. Before we turn the page, why don't we look at the official letterhead of the Attorney General's office? You see it there?
I see, yes.
Of course, that's not the letterhead that you used on October 1st, is it?
No, the two documents are...
You altered it, didn't you? Or you had it altered?
No, sir.
Mm-hmm. But focusing on Article 2 of the impeachment articles, go to the second page, Eric. Actually, third page. It's the last page, Eric. There we go. Would you do me the favor of reading the very last sentence in that paragraph?
Okay.
Please read it loud so our jurors can hear you.
Again. Please note, this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code.
It's pretty clear, is it not, that this letter does not fall under legal opinions as defined in 402.042, correct?
Well, Mr. Bangert says what it says. It's not a formal Attorney General opinion.
Right, but the article of impeachment says it is. And you know, as a lawyer, it fails. Right there, dismissed, right?
I don't know that.
Well, I mean, you allege, hey, you violated, you did something wrong, you issued an opinion under 402.042, and it takes us literally 20 seconds to show that's not true. That fails.
It's right on the face of the document that says this is not a formal Attorney General opinion.
Asking me.
So we impeached him.
It's like almost like somebody read the first 2 pages but failed to read the last
We
page.
impeached him for, among other
They drafted
things,
these articles.
writing an Attorney General opinion
You're asking
to
me
favor
to
his friend,
speculate?
but it's not an Attorney General opinion.
How many
So-
foreclosures did this letter stop?
I don't know.
None. Did you know that?
I don't know.
Okay, he's back on form, guys. He's back on form. He's crushing again.
Now, grand jury subpoenas are supposed to be secret. Is that right? How does that work? Do you know?
I don't know.
Okay. Are you supposed to, I mean, would it be appropriate for somebody in your office to send issued grand jury subpoenas, copies of them, to some sort of outside lawyer who's not involved in the case?
No.
I think it depends on the circumstances.
Was it
does it now?
appropriate to send the grand jury subpoenas that Mr. Kamek had issued to Johnny Sutton?
I believe in this circumstance it was.
Was Johnny Sutton the office's lawyer at that point when that was done?
Johnny Sutton was never the office's lawyer.
Okay. Was he your lawyer when that was done?
What date was it done on, sir?
Exhibit
Oh,
35
dude,
of 127, Eric.
No. He sent copies of grand jury subpoenas outside the office to other people.
Hold on, Eric. Let me make sure I got it right. Let me
Yeah,
just-
no.
Before I grab the document, when would it ever be appropriate for either you or any of your subordinates to send grand jury subpoenas or copies of them to some outside lawyer who had not been hired yet?
That's a good question.
Object to the form. That's a misstatement. He doesn't know. He doesn't know when he'd been hired.
Well, let's figure that out. If you're asking me, I'll ask him. We were told previously that, you can't know when he was hired, so let's figure it out now. When did you hire Johnny Sutton?
I believe we retained him during that last week that I was First Assistant Attorney General.
Whoa.
Personally.
Wait a minute. You're telling us that you hired and retained Johnny Sutton while you were still at the office?
Correct.
And at the same time, you're allocating $50,000 to retain him?
And we make the decision not to do that.
Wait a minute. Okay, help me on this. This is news. You're saying under oath that while you were an employee of the Attorney General's office, before you resigned, that you had already hired Johnny Sutton. Is that right?
I believe that's so.
What date?
Ooh.
First contact.
He says in his subpoena, trying to quash the subpoena, it was before you went to the FBI.
I think that's correct.
Okay, so now we're all clear. You personally had hired Johnny Sutton, an outside lawyer, in your individual capacity before you went to the FBI. Is that right?
Correct.
And at the same time, in fact, the next day on October 1, you were telling Lacey Mays and the controller to set aside $50,000 for Johnny Sutton?
For the office to retain Johnny Sutton.
You were going to have Johnny Sutton represent you individually and also the office, and you were going to have the office pay for it?
Oh, dude, what were you doing?
That sounds correct.
Dude, no. Dude.
It is not uncommon.
You realize now what you just testified to?
Could you let him finish, please? Just finish his answer.
Do you realize what you just testified to?
No, sir.
You just told this entire jury that you had hired an outside lawyer in your individual capacity before you went to the FBI on September 30th, 2020. And the very next day, you were instructing your subordinates to set aside $50,000 for Johnny Sutton.
And the agency never hired Mr. Sutton. The agency never paid any money to Mr. Sutton. The decision that we made was the agency not to hire him. That never happened.
The decision we made?
Me and the other.
At best, you're inviting your own lawyer into an explicit conflict of interest. That's the good version.
Can you help me understand?
At best,
I guess you've told me now.
At best, you've hired this guy to represent you
Was he an individual
in
lawyer?
your dispute against the AG's office. At the same time, you're having the AG's office hire him to work for the AG's office, inviting him into the most explicit conflict of interest ever.
Secret.
That's the good version.
That had been issued.
Matt Harris, please tell our contestants what the bad version is.
That they were able to do that because Johnny Sutton was their personal lawyer?
I believe it was done pursuant to a request from the FBI.
To send to Johnny Sutton?
To send to Sutton and then to the FBI. That's what I understand.
So the FBI, these subpoenas that everybody's complaining about, at least those folks, were sent to the FBI 3 years ago. Nothing's happened so far, right?
Also, incidentally, because you yourself are also a lawyer and are directly inviting another lawyer into an explicit conflict of interest, you're also violating your own ethics. That's the good version. It gets worse from there.
Are you here testifying in any way that Nate Paul had anything to do financially with the renovations of Angela and Ken Paxton's home?
I only know what I've been told.
Told by who? Again, you mean Rylander and Wicker?
Remember, I testified before lunch about that, sir.
Okay, did you ever make any effort to confirm that what you had been told by one of those two was correct?
I did not.
You know, the non-good version, it could look like, it could to a person look like self-dealing.
You'd have to ask them, sir.
I will.
Or even embezzlement.
I never asked them if they looked at the invoices.
Or even an attempt to get your personal lawyer on the inside so that they might be able to extract information that would help you in your case or something.
Nate Paul had anything financially to do with the renovation of the Paxton's home?
Did your lawyer did your lawyer recognize that he was being invited into a criminal conspiracy?
Support any allegation that Nate Paul paid for any of the renovations of the Paxton's home.
You know, I appreciate that every lawyer may not understand like more subtle conflicts right away, but like, did your lawyer not notice the obvious and glaring conflict?
That's a witness.
That was like the most glaring, obvious conflict of interest ever. You are my personal attorney for me as I'm about to leave the Attorney General's office because I'm a whistleblower. Also, I'd like to have you hired by the Attorney General's office at the exact same time. There's not a lot of great ways of spending that, people. I guess if it was the most walled garden ever, but no, not even then. That's because he's the first AG. Okay, yeah. And he's using taxpayer monies to do it, of course, so there's that.
Let's talk about this forensic report that he introduced as Attorney General 3.
That probably violates a couple laws relating to, you know,
about
honest services fraud and embezzlement and official corruption, violation of oaths, and probably a couple other things if I put my thinking hat on. My brain hurts
Please
now.
speak up. You're speaking softly.
Thank you very much, Your Honor. I've been mindful of my failings in this regard. Let me ask you.
Also because apparently, oh my God, it even gets one step worse. Because you were knowingly and purposefully involving your attorney in an ongoing fraud.
So that the jury remembers.
Guess what that means to attorney-client privilege?
Was what date?
Was the day before, September 30th.
All right. And on the date, the date.
So can we call the attorney to the stand? We sure can.
You sent.
Attorney-client privilege just disappeared into a nice little puff of smoke. It happened right before our eyes. It was
To
magic.
the Attorney General asking to meet with you.
It's actually October 1st.
That's October 1st.
Holy shit.
The gathering of all of y'all that we've talked about in that conference room where you found out about the subpoenas was on what date?
That was the 29th.
All right. And on the 29th, I think you described the mood everybody was in and the concerns everybody was. On the 29th, is that when you initially thought and talked about setting aside $50,000 for the group of you to represent Mr. Sutton, the Attorney General's office, as opposed to you as individuals?
Correct.
What was your thinking as to why
The Sutton subpoena was quashed?
for their
Yeah, well, they didn't know what they knew now.
General's office?
Because we were trying to navigate
You know?
through this with potential.
Yeah, they didn't know what they know now, so maybe we can get that subpoena reissued.
Who had
And if
that
not,
type
someone
of
else might have some questions for him.
experience at that level.
All right, you knew Mr.
Woof.
Sutton had criminal defense lawyer as well as previous criminal prosecution experience, did you not?
I did.
All right.
Yeah, Sutton's subpoena was dismissed.
You know him from
Maybe we should reissue that sucker.
I didn't know Mr. Sutton very well.
But most of you did.
It did. I knew one of his, I guess, former partners really well, which was John Ratcliffe.
All right. That at sometime that day, did you as a group decide that was not a good idea?
We did eventually decide that, yes.
Was that after you had authorized the exercise of paperwork to make it possible?
Well, what we did again was my email was making sure and seeking confirmation that there were funds in the event we decided to do that. We did not do that. Had we done it, we would have gone through, we've gone at length through.
Yeah, that's one way of characterizing it. A more aggressive prosecutor might. Your explanation is we were putting money aside with an idea of potentially hiring for the future, and we decided not to do that. A more aggressive prosecutor might characterize it as a substantial step
That process would have
in
been
furtherance of a criminal activity might qualify as attempted fill in the blank.
Before funds are expended or a contract is executed.
All right. So before a contract could have been worked out with Mr. Sutton, you would have had to go through all of that. If you were going to do it on behalf of the agency, you would have to go through all that cumbersome process, correct?
That's correct.
And how long would that have taken ordinarily?
I mean, it can be done within a day or so.
All right. But in the meantime,
for Mr. Rule of Law, I have to say that, the ethics are not really completely up to snuff.
different agencies, different possibilities.
I had this guy's back mostly until then, and that's where this guy lost me. Just in case you guys wanted to know, that was the point where Uncivil broke. I was willing to let this guy slide on a lot of stuff, which, you can judge me for my temperament one way or another as you like. But I'm just telling you, okay? I was willing to let this guy slide on a lot, because he thought he was doing the right thing for the righteous cause. And, he made some mistakes along the way, and he made some missteps along the way, but he ultimately was doing what he thought was right, for the better good. I was willing to let a lot of stuff slide, but right about the time he tells me, I had hired the guy in advance and then also tried to get him a contract from the AG's office is the point where the guy lost me, just in case you guys care.
Thank you very much. Now, if I could, would you please tell me when it was in this process y'all decided to go to the FBI and hire Mr. Sutton personally on y'all's behalf rather than the agency?
We initially contacted.
I'd also like to point out that this is their starting witness. It's not going great right now.
The agency doesn't need to contract with Mr. Sutton later on the 1st.
So was there ever any attempt to get $50,000 from the agency, to use $50,000 from the agency, or follow up at all on authorization?
We never started the memo process at all.
That is definitely not the same question he asked.
Are you aware when we're talking about computer time and everything of universal time?
Say that again?
Are you aware of universal time?
I'm aware of universal time.
Now that you say it, I am, the concept.
I want to just get a note if I can.
Their star witness has problems. I mean, you know, yeah. The best I can offer is that, you know, sometimes in cases, sometimes your witnesses are crap, particularly in criminal cases, because, you know, that your available witnesses sometimes are kind of, you know, not necessarily the most reputable characters, and so you're forced to call, you know, the crack dealer as your witness to whatever because they happen to be there at the time, because, you know, nefarious shit. But you know, he is supposed to be the first assistant AG, so that analogy doesn't really work. Or maybe it does. Maybe you think the first assistant AG is just as corrupt as your local crack dealer. I'll let you decide.
Universal time is, which is what this was. It would have been at 8:39 the day before, not on October 1st.
That makes sense.
If what I have just said to you is true and accurate, would that have meant that y'all were still talking about authorizing the money on the day, on the 30th, as opposed to the October the 1st, as Mr. Busby was saying?
Yes, sir.
Of all the attorneys in all the world to hire at the AG office, it just happened to be your personal attorney that you had also just hired.
Did Mr. Sutton?
He was the most qualified person for the job.
I believe so.
Okie dokie.
And by that time, had y'all orally retained him to represent you individually instead of the company, the agency?
Yes, sir.
Do you have any evidence or knowledge at all that Mr. Sutton even knew that y'all had originally talked about retaining him for the agency?
I had no discussions with him.
Okay. So would it be consistent with your level of knowledge that Mr. Sutton would not even have known that y'all had talked originally about hiring him on behalf of the agency?
Based on my knowledge, that's correct.
All right. And then finally, he asked you about this one issue. He asked you about some grand jury subpoenas. At the time that the grand jury subpoenas were shared with Mr. Sutton,
do you have any witnesses that weren't trying to?
And was he representing y'all individually?
Yes.
And of course,
what is your
of course now you can make a potentially colorable argument, and it just continues to get worse, pile. Depending on what other people knew at the AG's office, depending what these other people knew that were in up arms, that were involved in the removing of the letterhead and stuff, depending on their involvement,
you had retained him.
I did not.
If they were in an agreement, if they were in an agreement,
more areas.
And then this guy went and tried to hire his own lawyer,
Carrington Coleman, Mr. Coleman,
to work for the AG's office,
criminal cases. So when I was a first or
and he took an overt step,
did do a couple criminal cases
in furtherance of the agreement.
What is your experience?
They have a name for that too.
What they believe may be a crime to law enforcement. Do they wait till they're able to establish beyond a reasonable doubt before they report the possibility of a crime?
I don't think that's what you do.
They have a name for that too.
To the FBI, did you go with them to express your concerns and hope that they would look into it?
We just wanted to tell them what was going on.
Did you make any determination as any kind of expert on criminal law as to whether things were or were not a crime?
Not at that time, no, sir.
All right. Finally, on this area, regardless of whether it's a crime, what is your position as whether you were concerned about two particular areas specifically? Whether or not what Mr. Paxton had been doing and authorized and loosened on the world was an abuse of office. Did you have any thought about whether it was an actual specific crime for this or not? What was your thought process?
I thought I had a belief that it was.
would you still have that belief even if it turned out this or that individual thing was not a crime?
That was based all upon what I knew at that time.
What do you mean?
Well, we knew what we knew. I mean, knowledge on that date. Therefore, based upon the actions that I discussed with you earlier today.
What was your view as to whether or not, if the Attorney General's office, when its own internal people believed the incident at issue was not a crime, if they did not, and it should not be investigated and should not be
it wouldn't be RICO because Texas just invented RICO this year, so there is no Texas RICO. So they got that going for them.
Hired to go out and
or there wasn't at the time because they just invented it just now.
Punish the enemies of a friend or a donor.
So as of the first, there's now a Texas RICO, but obviously ex post facto. So conspiracy was what I was looking for those of you playing along.
Objection, Your Honor. That was 3 questions, and it was all 3 of them were leading.
I believe he can answer
Sustained.
each. I'm sorry. Excuse me. Sustained.
Sustained. Yeah.
Thank you, Judge. Did you have an opinion as to what your really hardcore belief was as to that conduct that you believed he had engaged in, as to how that complied with the oath of the Attorney General of the state of Texas?
Yeah, I believe that it violated the oath.
Why?
Because he was taking actions not on behalf of the state of Texas, but on behalf of one individual.
Against?
I mean, he was aligning against other parties, in the case in this, against law enforcement.
Did you have an opinion one way or the other whether he was, by what he was doing, it was interfering with federal and state investigations, criminal investigations?
I mean, that appeared to be the case.
Okay. Finally, if you signed on, you authorized the intervention in June of 2020 into the Mitty Foundation case against Mr. Paul's companies, correct?
I did, yes.
If
that would be leading.
And what you knew now, would you ever have authorized intervention?
I would not have.
That's all I have.
Thank you. Are we done with this witness? Thank God.
Yes, Your Honor.
Oh God, we're gonna recross. There should be a law against this.
You told us all that it was against the charity and for Nate Paul. That's what you said? The intervention?
The intervention was to intervene into that lawsuit, yes, sir.
No. You told us, in response to the leading questions of Mr. Hardin, that the intervention was against the charity and for Nate Paul. Isn't that what you said?
I think what I meant to say, if I said that, and I'm not so sure I did, it was to intervene into the lawsuit between the two parties, and then there was also, as you know, an investigation into the charity.
So it wasn't against the charity, was it?
It was to intervene into the lawsuit.
Yeah. It wasn't against anybody. It was an intervention, wasn't it?
The intervention was an intervention.
It was an intervention that you authorized,
on
right?
June 8th, that's correct.
And you also authorized an investigation, didn't you?
I believe on the same day or about the same day, yes.
And the impeachment articles, pull it up, please. Article 1.
He's already dead, dude.
Let's look at it. Paxton,
but sure, let's spike the football.
Employees of his office to intervene in a lawsuit. You see that language?
I do, sir.
He didn't cause anything. That's something that each of the people on the executive action memorandum approved. Isn't that right?
We'd ask those people who on that memo.
Yeah, I'm asking you. You're on the memo. You approved it.
I did approve it.
Okay. So this article is hogwash, isn't it?
I think we would need more information.
Do we? Do we need more information? You said Ken Paxton did a thing.
And you were telling us.
And he literally didn't do the thing.
Well, those timestamps in these documents that were given to our side, at least, by Mr. Hardin's
the thing
office,
is, normally you need
those were universal.
Normally
times?
you need this thing called actus reus.
I was reading the document like.
And you don't have it.
I'm just asking about what Mr. Hardin,
so that's a problem.
back and forth you had with Mr. Hart. He asked you about universal time, remember?
Yeah, that's a minor issue.
Reference to universal time.
Okay, and you were telling us that universal time, that these documents would not have been 1:30 in the morning, but would have been 8:30 prior? You don't know?
What I know is it is very extremely unlikely that I was looking at any email at 1:30. Now, 4 a.m., 9:30 p.m., yes. 1:30, I don't think so.
Well, let's real quick. I believe it was 368, AG 368, if my memory serves. And let's go to the authorization email.
I got to clip out that
So
thing
the
about him
members of the
basically
jury
admitting to
are clear
crimes.
about what
I
you
got to
were
clip
up
that
to.
out and post that too.
Can you tell us whether you had already retained Johnny Sutton at the time you sent this email to Lacey May?
On a just like what the F level, how can the first assistant AG not realize that basically he's testifying to something that could be perceived as criminal activity? How do you not realize that? Because either he's really good at acting dumb or he is that dumb.
That you retained him.
How do you not realize that, wait a second,
can we agree
this might
that you
be a
had retained
problem?
Johnny Sutton individually before you went to the FBI?
I'm testifying to things that at best
Can we agree that after
look
that,
like an ethics conflict.
according to you,
And
the
it goes
story
worse
is
from
now,
there.
y'all were also thinking about hiring Johnny Sutton for the office itself, right?
Am I just radically overqualified
Wouldn't that be a conflict?
as a lawyer? Am I just massively
Johnny
overqualified?
Sutton, represent
Because
you in your individual
apparently,
capacity,
I mean, I could see it.
and also represent the Attorney General's office.
Am
when
I
the actual
am I
client in the
massively
Attorney General's
overqualified or
office
something?
would
What
be
the hell?
The Attorney General himself.
That's why we wanted to meet with the Attorney General, among other matters, on October 1st.
You're telling this jury, all public servants, all elected, that you thought it was okay for you to hire some outside lawyer in your individual capacity and to also even discuss the office might hire him as well? You think that's okay?
I think it can be okay, yes, sir.
Really? I suppose if me and Matt put our thinking hats on hard enough, we might be able to think a way that this is legal. But we're going to have to try.
Texas taxpayers for your individual representation.
Matt and I are going to have to put our thinking hats and think, okay, how is this legal, ethical, and totally above board? Okay, Matt, go. What's your pitch? What you got?
No, we made the decision.
I think that this could be totally fine.
By the agency.
Uh-huh. All right, let's make this work.
Told us how, all this stuff was done for Nate Paul. Remember talking about all that?
How is Matt not a mod, by the way? Do you want to be a Matt mod?
Nate
You're not
was
here
a pain in the
enough.
butt, wasn't he?
But then you can post links or stuff. Do you want to be a mod?
He was a constituent that wanted
One of you
action,
drop by?
right?
He certainly emailed a lot of people in the office.
I mean, I said in the opening statement, when he said jump, he wanted you to jump and just hope you jumped high enough, right?
I think we've examined his contact with me.
You've heard the term the squeaky wheel.
I did not have relations with that woman. At least Bill Clinton had a very, very technical argument.
Services.
So
somebody who's a real pain, who was over and over and over demanding action. And sometimes
Bill Clinton was technically correct, is the best kind of correct.
That does happen, yes, sir.
Yeah.
But that's why he's a smart guy.
That's how Nate Paul was. Isn't that right?
He was more than that.
Yeah. He sent letter after letter after letter after letter making threats and accusations to the AG's office, didn't he?
He did, through his lawyer and himself.
Yeah, email after email. He was incredibly unhappy with the action of the AG's office, wasn't he?
I believe at times he was, yes.
He was madder than a hornet's nest at times at the AG's office for what he called incompetence and failing to act. Isn't that right?
I mean, the best source of that would be...
Apparently Ken Paxton has his own deep state problem
And you
over
know
there in
this
the
is true
AG's
because
office.
He sent
guess.
you all of his correspondence that he had been sending to Josh Godby, accusing Josh Godby of having a conflict. Remember that?
Excellent.
I don't know if he sent me
All right,
all his
Matt, you get to be a
correspondence,
mod.
but he did send me correspondence.
I mean, he claimed the AG's office had a conflict because the spouse of the receiver in the case worked at the AG's office, right?
If you have it, I could look at it.
Yeah.
I don't.
And he thought that that was the reason Josh Godby wasn't doing anything, because Godby had a conflict. Isn't that right?
If you could show me the documents, I could look at it.
Well, he sent them all to you. Don't you remember? And we looked at them in your direct.
We didn't look at all of them, sir.
Okay. Let's look at AG Exhibit 219, Eric. I'm just going to hit the high points. This is an email Nate Paul sent to you in July of 2020, where he was very upset, very frustrated with the AG's office. Do you recall receiving this email?
1 second, sir. It appears to be familiar, yes, sir.
He says, these emails started a month ago and continue to be ignored. See that part? First paragraph, last sentence.
I'm looking.
Yeah,
That's
Trump
what it
needs to
says.
hire this team, no doubt. Yeah, Trump
the
needs to
next
hire
page,
Bixby over here. It would take a
Sending you
shit ton of
A ton
money.
of different emails that he sent to
I would need
Josh
a really
Godby.
big
Here
check.
it is where he tells
I mean
Josh.
a big
Josh
check.
was your direct subordinate or one level below you?
I don't even know how big the check
Josh
would be,
have
but it's going to be
reported
big.
to the deputy for civil litigation,
Which was?
Darren
$10
McCarty.
million.
Okay, so this would have been you,
How
McCarty.
big is the retainer,
Josh
do you
Godby.
think, if you have to take
okay,
on
with an
Trump as a
associate
client?
deputy
Because Trump is a pain in the
McCarty
ass.
there as well.
How big is that
Here he
retainer?
tells Josh
It's going to be the biggest
Godby
retainer
blank.
ever.
You've exhibited highly unprofessional behavior. You see that?
Thank you, Matt, for the 99
Yes, I
cents.
read that.
Appreciate
He
it.
says your relationship with Greg Milligan, that was the receiver in the Midi Foundation case, wasn't it?
I don't know.
Well, we all know.
And Trump
He
has a
says
history
your
of not
relationship with
paying
Greg
people,
Milligan and
so you definitely
opposing
want that
counsels
money in the
clearly
bank
affected
before you
your
lift a
ability to be
finger.
neutral. You see that
And make that
language?
real
I see
clear.
the language.
He's
Money
accusing
is in the
you-
bank before I
This has not been admitted into evidence
even
yet, I believe.
breathe.
219 is not in evidence? Your Honor, we offer 219, just to make it fast.
Any objection? Continue.
Thank you, Your
It's
Honor.
admitted to evidence.
Thank you, Your Honor. Looking at he accused the AG's office of having a conflict of interest, didn't he?
Did you read that?
Yes, sir, I did. Clearly affected your ability to be neutral. That's called conflict of interest, is it not?
Yes.
It says not to be neutral. That could lead to a conflict of interest.
Could? It could lead to a conflict of interest?
I'm just trying to figure out how Nate Paul had the keys, as we've been told, to the AG's office when he keeps haranguing the AG's office for failing to do its job.
Yeah, that's a good point.
Answer to that?
Any answer to that? He certainly.
Let me go to this.
Would you like me to answer or no? No?
You can answer. If you have an answer as to how we are being sold this bill of goods, that the AG's office had been handed over to Nate Paul, yet we see the real-time correspondence where he's haranguing the office over and over and eventually haranguing you. You see that, right?
Now, can he answer the question, Your Honor?
Thank you, Your Honor. Let's take a look so we can end this up. Exhibit.
Your Honor, I asked those last questions then. Objections to be stricken from the record. He asked this question. He gave a speech. If one looks at exactly what he did with his answer there, witness asked if he could answer. Do you want me to answer? And then he gives his speech about, well, if you can do so-and-so, and then he withdraws the question. So he's made a speech and testified and not allowed the witness to answer. I respectfully ask that last question be struck, and he be allowed to answer the question before that.
I'll withdraw it, Your Honor. It's fine.
I'll bet.
Ooh, snarky. Ooh.
Finally, Eric, let's look at Exhibit 127, Exhibit 40.
That's like the third or fourth time today that Randy over there has had some sort of snark. He snarked at
What does
opposing
the
counsel.
litigation hold?
He snarked at the
What does that
judge.
mean in the
I think he snarked at the
parlance
jurors
of
at one point.
lawyering?
Well, what it means is when you either send or receive one, it's to not delete anything.
Does that include text?
It includes any correspondence that's relevant to the subject of the request.
Now, would you agree, I mean, you've been a lawyer for 26, 27 years?
Actually longer.
Okay.
I was licensed in 1990.
Okay.
So I think that means I'm 33 years.
33 years.
Yes, sir.
Okay. You know, as a member of our profession, that when you send a litigation hold letter, that means preserve everything related. I may be suing you, right?
That is true.
Did you know that Nate Paul's lawyer sent that to the AG's office?
Yeah, on October 11th, 2020.
Yeah, so 9 days after you left, Nate Paul was threatening to sue the office for inaction, for having a conflict, etc. Isn't that true?
I mean, this is a letter that's sent to.
Thank you,
Mr.
Austin,
Webster,
Procurier, and
Mr.
Apostle.
Paxton.
Thank you.
I'm not at the
First super chat ever.
I can read it. if
That's
you
very
like.
nice.
You have it.
Thank you for letting me be your first super chat ever. That's very kind.
Your Honor, with that, I pass witness.
Please dismiss. Please excuse the witness. If you allow redirect, I'm going to.
Ready for the next
Really?
Wait.
Witness is excused.
Thank you.
May this witness be excused, and of course stay available if there has to be some recall, but certainly not around.
You're excused. Subject to recall. You may step down.
Are we done with the day, or are we still pressing on? It's 4 o'clock. Can we end the day early?
Your Honor, we call Mr. Ryan Bangert.
No, we can't. Okay, we're pressing on.
To both parties and the jurors, I plan to go to about 6:30 this evening, depending where we hit a point. It may be a little earlier, a few minutes later, since we started a little late this morning working on other
We got
issues.
2 more hours of this.
We'll take a break, members, a snack break here for everyone.
I need a snack
Another
break.
30 minutes? Okay.
All right. I need a snack break. All right. Overall impressions of the witness. Well, we did a lot to sort of question his. We did a lot to sort of question his thoroughness in his ability to get information relating to problems that he said he observed. And then we also did stuff to question his integrity. And then we're like, is it a conflict of interest? And we're like, maybe. And, okay. Yeah. So, I'd like more witnesses, please. You know, maybe someone who's slightly
If that's okay.
less
That's okay.
questionable on the whole massive, obvious,
Members, we're
blaring.
not on a break. We're just waiting for the other witness to come in. Just want to let you know. But feel free to
You said
stand and
snack break.
stretch.
You said snack break. Yeah, so, yeah. In the most blaring, obvious conflict of interest possibly known to man, I've hired a guy to represent me personally as I'm about to leave the AG's office in respect to this whistleblower blah, and also simultaneously setting aside $50,000 of taxpayer money to hire him to work for the AG's office that I myself am leaving because of this massive corruption. So it's hard to configure that story in a way that, like, oh yeah, that totally makes sense. You know, that totally makes sense. Oh, that explains it all. I'm having a tough time in my mind coming up with a scenario where all those things can be true at once. That seems tough. Yeah. That seems tough. I also want a granola bar, but I have no granola bars. It's very sad for me. This was their least controversial witness? Oh, that's good news. Okay. So, yeah, I'd like to hear more before I decide on the issue. The Paxton's lawyer is badass though. He's very, very good. He's very, very good. The worst that can be said for him is he got a little lost in the weeds at one point. Which, you know, he was trying to demonstrate the things that he didn't know were the things he didn't see, and he got a little lost in the weeds, is the worst criticism we can say. So,
Mr. Banger, come forward. I need to swear you in. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Thank you.
Good afternoon.
Good afternoon.
State your name, please.
Ryan Lee Bengert.
All right. Mr. Bengert, I want, if you will, to keep in mind a couple of things. The way you're positioned is perfect for the microphone, I think, in every respect. You don't have to take your hands down. And if you think I am not very, if I've moved to go out inadvertently, I want you to call me on it and vice versa. Okay?
you're not what?
That's fair.
How old a man are you?
I am 46 years old.
And you might want to be a little closer to the microphone, or but see if you can. I think you can bend it towards your face. It might work out a little better. All right, thank you. Where do you live?
I live in Bee Cave, Texas.
So could you take us through and try about a minute and a half, sort of your own personal background, where you grew up, your parents, etc.?
Certainly. I was born in a small farm town in Illinois called Quincy, Illinois, about an hour north of St. Louis on the Mississippi River.
What did your parents do?
My father's a salesman. He did not complete college. My mother's a school teacher.
And do you recall, what size town was this, by the way?
40,000, give or take.
And that's a little bit bigger than my 9,000 in North Carolina, so 40,000 we considered a big city. Let me ask you this. When you finished high school, where did you go to college?
Certainly. I moved to Fort Worth, Texas when I was in second grade. And did grade school there, high school in Omaha, Nebraska, and then I went to Oral Roberts University for college, which is in Tulsa, Oklahoma.
And then what about law school?
I graduated ORU in 1999 and started law school at SMU in 2001, and in the intervening 2 years, I successfully pursued my wife, who agreed to marry me.
And where did you finish in your class?
At SMU?
Yes.
I was first in my class at the law school.
Nice,
And
good
where
for
did
you.
you go from there?
From 2004 to 05, I clerked for Judge Patrick Higginbotham on the Fifth Circuit Court of Appeals.
And after that, in 2005, and let me stop you there. You would have been approximately what age by the time you finished clerking for the Fifth Circuit?
I only graduated in the top third of my law school.
I was 28 years old.
So,
Had you picked, by that
respect.
time, had you also been involved in Republican politics or other outside activities?
I had been at Oral Roberts University. I'd been the student body president, but I'd also been an officer in the college Republicans. I had interned for a Republican congressman on Capitol Hill named John Christensen from Omaha, Nebraska. I'd also served on his campaign. I'd been an intern for a group called the Christian Coalition. I'm not sure if they exist anymore, but I was an intern for them back in the late 90s. I also was a Blackstone Fellow in law school.
yeah, thank you to the 630
The
currently
Blackstone
watching.
Fellowship is a
Appreciate every one of you here.
fellowship,
Just
a
a kind
summer
reminder
fellowship
to hit that
program
subscribe
that
button
is administered
if you
by
haven't
the Alliance
already.
Defending Freedom.
We really do appreciate
And
everyone who
we
helps to
collect
subscribe.
What we would say are the best
Hit the like
and
and
the brightest
retweets for those of you who have the Twitters.
based law
You
students
could
in
hit
the country.
retweet that
We trained
pinned
them
link.
for about 2.5 to
Probably
3
will
months.
help grow the channel and stuff.
Originalism,
So
textualism,
all
natural
that's
law. We give them
appreciated.
Excellent access to internships, and we also commission them as fellows.
Mr. Banger, tell me this. What role has your religion played in your life, both as a student and as an adult?
Very significant. It's
In
the
what way?
basis for everything that I do.
And has that always been true, or was that later in life?
It's always been true, and of course, as anyone would tell you who's been a believer most of their life, you have your ups and downs, but certainly it has been the guiding star in everything that I do.
You're aware, or you're not, of the allegations that have been made publicly, and indeed by Attorney General Paxton and others similarly involved from his point of view, defenders of his, that this impeachment process itself is somehow in the hands and caused by outside groups that do not share conservative values. You're aware of that?
I have heard about that, yes.
All right. Would you please tell us and give me an idea of, for instance, your political philosophy, in the sense if we on a scale of 1 to 10, and 1 is very, very, very far left, and 10 is very, very, very far right, where do you fit in?
Well, I don't think anyone would have ever accused me of being far left. In newspaper articles describing me leading up to this trial, I was described as working for an extreme conservative group. I believe I work for what I would call a Christian legal advocacy organization, but my politics are very much conservative. My party affiliation has been and always will be Republican, and I have long been associated with what I would call the conservative legal movement. That includes the Federalist Society, the Philadelphia Society, and of course the Blackstone Fellowship.
So if someone would refer to you as a rhino, what is your reaction?
That would be remarkable, and I can't imagine that having any basis in reality.
What are you presently doing? What is your present job?
I presently am the the senior vice president for strategic initiatives and advisor to the president for a group called Alliance Defending Freedom.
Called what?
Called Alliance Defending Freedom.
And the Alliance Defending Freedom is what?
We are a global legal advocacy organization. We specialize in defending religious freedom, freedom of speech, life. We also work very closely on campus with groups who are having their free speech stifled by universities. We also support parental rights. I think that it's fair to say that if you were to put us on a political spectrum, we would be conservative very much, although we are a nonpartisan organization.
At the time, the jury has just heard for several hours from Mr. Mateer. How long have you known him?
I've known Jeff for quite a while. I knew him back when he was at First Liberty Institute prior to joining the Attorney General's office. And I did several cases with First Liberty Institute as a volunteer attorney when I was practicing law at Baker Botts, which I don't think we've talked about, me joining Baker Botts, but when I was there, I was a volunteer attorney for First Liberty.
Yes, when you left law school at SMU, and then after you left clerking for Judge Higginbotham, what did you do?
In 2005, in the fall, I joined Baker Botts in Dallas, Texas. I was an associate there until 2013, I believe, when I made partner as a litigation partner. I was there as a partner until 2016. Right after the election of President Trump, I received requests that I consider joining in the government. At the time, we weren't in a position life stage-wise to go to Washington, D.C., and so I was asked by then Attorney General Josh Hawley to join his administration in Columbia, Missouri. And we had some back and forth, but he's a very persuasive guy.
So when you joined him, what position did you have with Josh Hawley?
I was the deputy for civil litigation, so I ran all the civil litigation in Missouri.
And what was his position?
Josh Hawley was the Attorney General for the state of Missouri.
And of course, since has gone on to other things.
He has. He ran for and won the U.S. Senate seat in Missouri over Claire McCaskill while I was there.
Can we safely concede that Senator Josh Hawley is a very conservative man?
He's a very principled, conservative man.
And how long did you work for him in the capacity as Chief of Staff?
I was 2 years, and I was the deputy for civil litigation.
I'm sorry. Did you obviously end up being offered another job before you left?
I was spoken to by the incoming Attorney General, Eric Schmidt, about potentially joining his administration. Incidentally, Mr. Schmidt is now the junior senator from the state of Missouri. But during that time period, immediately after the 2018 election, when Josh had won the Senate seat and General Paxton had won re-election, Jeff Mateer and I were texting back and forth, and Jeff said, "I think it's time for you to come home."
Did you do so?
I did. I know Brantley Starr, who was a friend of mine and at the time was the deputy first assistant in the office, had been nominated by President Trump to become a federal judge. And Jeff recruited me because we knew Brantley was going to be leaving.
Could you imagine how anybody could be legitimately contending you and Mr. Mateer and the team that was put together at the Attorney General? How could anyone reasonably, legitimately contend that you guys were some kind of ultra-liberal force that was designed to take over and thwart the true conservative mission?
Assumes facts, not in evidence and relevance, Your Honor.
I'm sorry. I'm simply asking you about it. Can you imagine how anybody could take that position? I thought I was taking a shortcut to bringing in evidence on it. All right.
It would be fantasy, pure and simple.
All right. Now, let me ask you, when you left and came back, did you come to work then for the Attorney General's office?
I did. In January of 19, I joined the Attorney General's Office of Texas as the Deputy for Legal Counsel.
And what were your duties as the Deputy of Legal Counsel, and what month did you come back?
January of 2019.
All right. And what were your duties? What did you oversee starting in January of 19?
The Deputy for Legal Counsel oversees a number of different functions within the office. Open Records is one of them. The Opinion Committee is another. The Public Finance Division is another. The General Counsel Division is another. And I was also tasked with overseeing a group called Special Litigation. Special Litigation is a strategic litigation unit within the AG's office that both brings and defends strategic key litigation on behalf of the state.
Now, let me ask you, do you recall the first time you might have ever become aware of a Mr. Nate Paul?
I do. When
was that?
It was either at the end of December of 2019 or early in January of 2020.
Was he on your, the evidence is clear in here that on August the 14th of 19, he had a search warrant executed by a combined state and federal task force at his house and businesses. Did you happen to notice any publicity or anything about that in August of 19?
No.
All right. What was the occasion for you becoming aware of Mr. Nate Paul in either December or January of December 19th or January of 20?
The Attorney General spoke to me about an open records file that he wanted me to take a look into. I also contemporaneously received an email from Jeff Mateer to the same effect.
All right. And did you talk to Mr. Mateer about it, or did he just forward you the request?
He forwarded me the request. I cannot recall whether I spoke with him or not, but I certainly spoke with the Attorney General.
What was the nature of the request that he referred to you to consider?
The request was basically it was called a reconsideration, a recon, of a previously issued open records decision that had been issued by the Open Records Division.
Had you ever before been involved in Missouri or any other, working with an open records request?
My time in Missouri, I was primarily responsible for litigation, so my experience with open records requests in Missouri was relatively limited, but by the time that this came about, I'd been working with it for over a year here in Texas.
Would you briefly describe for the jury the open records process as it is handled by the Attorney General's office?
Certainly, and I'll do my best to summarize. The Attorney General's office is responsible for ruling on requests by agencies or state governmental bodies who have received open records requests from citizens and who wish to withhold information based on an open records exemption or an exception. And the Attorney General's office will evaluate those requests and then rule on them through a series of letter rulings. We receive thousands upon thousands of these requests every single year. It's all handled through the Open Records Division. They're handled by a team of attorneys who specialize in open records law. And they are, let's just say that it is a well-oiled machine.
And what are we talking about when we say the law enforcement exception?
Yes, there are a number of exceptions in the open records provisions in Texas law. The law enforcement exception is one of those. It's designed to protect law enforcement when an ongoing investigation is taking place against having the defendant or other interested parties procuring information from law enforcement that would disrupt the investigation or potentially compromise witnesses or compromise safety, quite frankly, of those involved.
Does it matter whether the law enforcement agency is a federal or state or local law enforcement agency?
The rules apply slightly differently. The rules are designed for state law enforcement agencies, but we do, as a matter of comity, when there's a FOIA exception for federal law enforcement agencies, honor those requests as well.
But it is essentially a state statute designed, is it not, to regulate or respond to requests that would invoke local or state law enforcement, correct?
Yes.
But if something is to affect, say, if FBI is one of the agencies in a particular event, is it designed to address that as well?
It does.
How does it do that?
We have a number of open records rulings that we've issued, and you'll have to forgive me if I forget the numbers of them. It's been a while. But we effectively agree to honor requests posed by FBI or other federal law enforcement agencies to withhold information, oftentimes information that has been provided to state partners in the conduct of joint law enforcement activities.
So if there was a joint law enforcement operation to involve like 4 different law enforcement agencies, could be FBI, could be DPS, could be local police departments, it could be some regulatory agencies that have law enforcement capability and involvement. If in any of all those situations, does the AG's office treat that as a law enforcement exception agency?
It's law enforcement exception specifically with respect to state law enforcement agencies, and we'll treat that as a matter of comity, a law enforcement exception for the federal agencies as well.
All right, let's take the incidents that you said you were not aware of at the time it occurred involving Mr. Nate Paul. And among the agencies that were involved there were people from the Securities Board, all right,
Correct.
State agency, from the DPS, state agency, and also the FBI. Would any of those agencies be treated differently?
Functionally, no. No, they would not.
And what does that mean functionally?
It means that the analysis in the open records rulings differed slightly with respect to the agencies, but the outcome was always the same. We would not force those agencies to disclose law enforcement materials that were subject to the exception in the Texas Code for Texas agencies or FOIA for federal agencies. We would allow them to withhold that information. And I also want to point out these requests that were going to, the open records requests, were being posed to Texas law enforcement agencies.
All right. So a private citizen wants to complain about some matter in a search warrant or whatever. What would they do, and how would the process prefer? So let's say a private citizen and his lawyer want to get behind a joint operation by law enforcement and file a Freedom of Information request. How would that proceed?
Same as every other request. The request would go to a Texas agency or a Texas law enforcement agency. They would then submit a request for a ruling to the Open Records Division. And when the law enforcement exception applied, which in these types of cases where there are joint law enforcement activities taking place and they're ongoing, we would almost always withhold the information.
So if, in the example I cited, Law Enforcement Capability Board, Securities Board had people present, DPS had people present, FBI had people present conducting it, how would you proceed with each of those agencies?
The agency making the request to withhold would brief the issue. Interested agencies would then receive an opportunity to submit their own briefs.
Let me start here. If the request went to the Securities Board, what would be the process then, if the first request went to the Securities Board?
The State Securities Board would, if they wish to withhold information under the state law enforcement exception, the Securities Board would submit a request for a ruling to the Attorney General's Office Open Record Division. That request would then be adjudicated by our attorneys. And sometimes there was additional briefing. If there's a party who was seeking the information who wanted to brief the issue, they would submit briefs and we would rule upon it.
All right. And then what would you do about if there were other agencies that had information in there? And obviously, if the request originally went to the Securities Board, whichever, would there be
Could you ask a question that I don't know the answer
from
to
DPS
automatically?
and from the FBI?
Like,
How do you handle that in letting them know whether they can weigh in?
could you give me an answer to something I don't already
The
know?
pending request and given an opportunity.
What is an open records request?
They would be notified
What do you think
as
it
well.
is?
Yes.
How do you
Would
guys deal with
notify
it?
then
How do you
each
think
law
we deal with
enforcement
it?
agency of the
You know,
request, even if it just went
Use
to
your
one of them?
use your imagination.
Okay.
You're probably
Now, at this
85% of the way
particular time,
there.
in December of 19, January of 20.
Use your brain
Describe for
parts.
the
What do you
jury
think?
How you got involved and what you did and what the request was that you were asked to look at by Mr. Mateer.
Certainly. There had been a request made, I believe it was to the State Securities Board, for information relating to the law enforcement actions taken against Nate Paul, concerning Nate Paul. And there were a number of different pieces of information and documents that were requested. I did speak with the attorney for Nate Paul.
Do you recall who that was?
It was someone at the Meadows Collier firm in Dallas.
Something in the Chuck Meadows firm in Dallas?
Yes, Chuck Meadows firm in Dallas.
Did you?
Had dealings with them before on other matters when I was at Baker Botts.
So you already knew the firm?
I did.
All right. So what did you do?
I spoke with them to understand the contours of their motion for reconsideration. Based on my review of the record and through conversations, it became apparent that the thing that was most concerning to the Meadow Collier's firm was getting access to a particular document known as a probable cause affidavit. This is the affidavit that would have supported the search warrant of Mr. Paul's home. There were multiple
And
ones.
did you discover whether or not that affidavit was actually under a federal seal in San Antonio?
I did, and I learned that it was under federal seal, yes.
And I'm not sure, you mentioned it, that I'm not sure we were clear before this. The actual event that gets to you, was that the first time the AG's office had been involved in this request, or were you being asked to reconsider a previous decision?
It's the latter. We were being asked to reconsider a ruling we had already made, finding that the documents should not be disclosed, and that includes the probable cause affidavit, should not be disclosed.
And do you recall whether the previous one had whether the FBI had weighed in on it as well, or was it declined initially without even hearing from the FBI?
I do not recall because I wasn't involved specifically. That would have been a routine matter, and the denial of the granting of those exceptions and the refusal to force disclosure would have been routine. It was unexceptional.
Was there anything unusual?
Was the airspeed velocity of an unlanded swallow?
In terms of
More than my brain
its
speed right
actual
now, I'll
decision
tell you that.
itself, namely that the law enforcement exception dictated that the information would not be revealed.
No,
Was there anything?
When I reviewed the decision,
All right,
it
so
was
so far
unremarkable
we've
to me.
learned
It appeared to me to be a straight application.
AG deals with open records.
And what did you do when you
Paul
looked
wanted
at it?
records relating to a
What's the
search.
first thing you did?
They said no.
Well, I
He said,
reviewed,
could you think about it again?
understood that there was a
They
motion
said
for
no.
reconsideration pending,
I have
so
now
I also
summarized all the
took
testimony
that
thus
issue
far.
to Justin Gordon. Justin was at the time the head of the Open Records Division and was one of my direct reports. I asked him to pull the file, to look at it, to evaluate the decision, and make sure that we had covered all our bases, because a motion for reconsideration, we did get those from time to time. They were almost in all cases denied out of hand.
Yeah, I was going to ask you that next. And in all the cases you touched or watched while you were there, how would you rank the number of occasions in which the law enforcement exception was not adhered to?
Difficult to quantify, but it was been a very unusual thing for a straight application of that exception not to be granted. In fact, I don't know if we ever did it.
So it would be accurate to say that you don't know of one that you had encountered?
I'm not personally aware of a situation where that exception applied where we would not have granted it.
Did you look into Mr. Paul at all yourself?
Say again?
Did you do any research on Mr. Paul?
I did.
What'd you do?
I Googled him.
The ultimate research tool.
Right.
And how did that impact your view?
It made me very concerned that I had been asked to, well, let me back up. I learned through my Google research that Mr. Paul had indeed been, his home and several properties been searched by the FBI.
The trial volume is
under
low?
active investigation by federal law enforcement. And as someone who is a senior
Yeah, it looks
staff
all right on my
member,
end.
that immediately sends up red flags when you're being asked
Do you need more
to
volume from the
review a
trial?
file
Looks
for
okay to me.
consideration to disclose law enforcement materials to someone who is under an active and very far-reaching investigation.
Tell me what the danger is, or what the policy position was in your agency in terms of.
Is anyone else having a volume problem?
Would you want to adhere
It looks
to
okay
this
on my end.
rigid rule that if it involves ongoing criminal investigations, you would cite the law enforcement exception? What's the reason for that?
The policy reasons, there are a number of
See,
policies.
one of the nice things in OBS is you actually get the volume markers, so you can visually see the audio levels
for that.
in
One of which
OBS.
is you would not want to compromise.
It's a nice
in
thing,
any
so
way
you
an
can actually
ongoing criminal
physically see
investigation,
where the volume
particularly by
level is
state
hitting,
agencies,
which you can't
by
do inside
releasing
StreamYard.
information, that could cause that
So OBS
investigation,
gives you that power, so you
yeah,
can be like visually,
not able to
like,
go
oh yeah, it
forward.
looks fine.
More importantly, you also don't want to compromise the safety or the identity of potential witnesses or the safety and identity of those who might be conducting the investigation. So there's both a public policy interest in ensuring the integrity of our law enforcement activities here in the state. There's also a public policy interest
When
in
I
ensuring
speak,
the
it's too
safety of
loud.
those
Checking 1 2 1 2 1 2. I mean, my volume is a little bit louder than the court's, but not by
I was
much.
about to ask you. Those
I could turn down my
files,
volume a little bit if my volume's too loud.
how often they have
Check 1 2 1 2 1 2.
personal data
Hello everyone, welcome to Uncivil Law. We're
with
yeah,
law
that'll
enforcement,
be about even.
Citizens who have given information but want to remain anonymous as much as they can, the names of people that are involved. How would you describe the potential risks of them if this information started being revealed to whomever was that one curious, whether it was media or the offender themselves?
Objection to relevance, Your Honor. I mean, it's not with regard to a specific document here.
I'm
It's an
sorry,
overly
repeat
broad
your
question.
objection. I couldn't hear you clearly.
It's an overly broad question, Your Honor. It doesn't specify what specific document that the witness is going to be referring to.
My question is, I'm asking him what the danger and the policies of these things, which goes directly to why they were going to be concerned about releasing this information to Mr. Paul.
Well, I think Mr. Bangert's already answered that question, Judge.
I'm sorry.
I would say that Mr. Bangert's already answered that question.
Overruled.
Thank you.
Could you state the question one more time, Mr. Harden?
Yes.
What?
My question is, I'm asking what is the danger and the policy of these things, which goes directly to why they were going to be concerned about releasing this information to Mr. Paul?
Again, safety concerns are paramount. You never want to compromise the identity or the safety of witnesses. And certainly, when I was reviewing files, and I only reviewed files that had what you might call hair on them, or files, in this instance, that didn't have hair on it, but at the request of the Attorney General. There were files where witness identity, sex crime victims in particular, might be revealed. Those were always very concerning. We want to make sure those were properly dealt with.
Hair?
Yeah. Mr. Banger, do your decisions when you were making these open records requests, if you're not careful about how you do it, are you ever concerned about your setting a precedent that would even be worse than the individual case you're looking at?
Precedent is very important to the Open Records Division. We want to be rigorous in ensuring consistency to the utmost. We want to ensure that as we apply the law, it is applied evenly and consistently for all Texans.
Well, then, if in fact you released the information that Mr. Paul and his attorneys were seeking, that would have given you, what kind of information would that have given them, the person under investigation?
I was very deeply concerned, in particular, about what it would have done to our precedent to overrule the law enforcement exception applied in this case being the reconsideration motion I was asked to review by the Attorney General, because there was a probable cause affidavit in play. Not only that, a probable cause affidavit subject to a federal seal that was part of an active, ongoing, multi-agency investigation. That would have been, in my view, a very poor precedent for us to set and would have disrupted law enforcement activities in the state of Texas.
Did it include what we commonly call offense reports, in which identifying data of the officers and the witnesses were included?
I'm not familiar with that term, but certainly...
Forget the let me give you, excuse me for interrupting. Let me see if I can give you another term. Would it have included memos about what happened and by whom and who did what, so that personal identifying data would be in there about law enforcement and anybody else, witnesses?
Certainly, law enforcement exception covers documents that contain personally identifying information for law enforcement and witnesses.
And would that file, that would also include the names and addresses potentially of victims
Objection,
or
improper
witnesses?
foundation, Your Honor. This witness hasn't,
Excuse
he
me.
hadn't laid the foundation to establish he has knowledge of the file.
I'm simply asking him what all is there that they're trying to protect.
Overruled.
Thank you.
There's a whole panoply of information that could be included within documents covered by the law enforcement exception.
So when this was over, well, let me ask you this. During your deliberations about this matter in January of 2020, did you have any contact with the Attorney General about it?
I did.
And what was the nature of that? When, where,
Certainly.
how, what?
Initially, the Attorney General asked me to review the motion for reconsideration. Unusual in the sense that he typically did not involve himself in open records requests, but he is the Attorney General, and I certainly wanted to honor and fulfill that request, so I reviewed it carefully, and I very quickly reached the conclusion that the decision was correct, and I advised him of such.
Let me go back for a moment. When you were hired, did you ultimately, though I believe you said that you were recruited by Mr. Mateer, but did you have contact with the Attorney General and meet with him before you were hired?
I had, not before I was hired, but I had contact with the Attorney General going all the way back to 2014 when I was a partner at Baker Botts. I contributed to his campaign. I supported him during his primary campaign. I believe it was against Mr. Branch. I believe I was the only partner at Baker Botts who did so, so I was told. But I believed in what he was doing. I believed his policies were the best for Texas. That's why I joined his office in 2019. I believed in what he was doing. I also believed Texas was leading the way in representing the interests of the conservative legal movement here in the U.S.
So would you characterize yourself as a strong supporter?
At that time, yes, I was. That's why I joined the office over other opportunities that came my way.
So in addition to this reconsideration request on the Paul case coming from the lawyers for Mr. Paul, where in that scheme of things did the Attorney General reach out to you as well and ask you to look at it?
Again, it would have been toward the end of December or beginning of January, either 19 or 20. He asked me to take a look at it. I did. I reviewed it, came to the conclusion that it was correct. Typically, in instances like that, the Attorney General would say, "Thank you for that review," and we would move on. This was different, and it struck me.
How was it different?
He pushed back, and he pushed back not necessarily by contesting my application of law, but by saying it doesn't seem fair to me that a defendant should not have access to something like a probable cause affidavit, something that's being used to investigate him.
Was there any conversation? Well, that would be a consideration for the judge and courts that were involved that he should go to, or tell me about any conversation or response you had.
There was federal case law on that point, and I shared that with the Meadows Collier firm, pointed out to them that all they needed to do was go to the federal courts and file motions with the federal judge, and if they were denied, they could go to the Fifth Circuit, and there was good case law there too, and I shared those facts with the Attorney General as well. There was a federal option.
What was Attorney General Paxton's response?
The Attorney General shared with me his view that he had been wronged by law enforcement and was uninterested in having other Texas citizens wronged by law enforcement as well.
Did he express to you any further, as far back as January of 20, his views of law enforcement?
He was clearly very skeptical of law enforcement when we were having those conversations. I was surprised by the level of pushback I got to what I viewed as a routine application of the law, but we continued to have those conversations with him all the same.
Well, once you made your view known, and once he pushed back, did you have any further conversations with him?
We had a series of conversations.
About this subject?
About this subject in January.
Excuse me, about this case as well?
We had a series of conversations about this specific open records request, the one for reconsideration of the SSB request, yes.
The one on behalf of Mr. Paul?
Yes.
How many times would you estimate that you had conversations with the Attorney General in which he was urging you Or was he, in these conversations, was he urging you to take a particular position?
He was certainly applying pressure to look for any way possible to disclose the probable cause affidavit. He did not instruct me to override or overrule our existing precedent at that time, but he was very interested in finding any way he could to have that probable cause affidavit released.
And what was your reaction?
I told him that that would not be a good idea.
So ultimately, was it disclosed at that time?
It was not disclosed at that time, to my knowledge, no.
How did the issue end? I mean, how did you move away from it?
I think we may have just worn each other out on that, but he
You what?
did.
I'm
We
sorry.
may have just worn each other out on that, but he did eventually. And of course, remember, we're now ramping up into COVID in 2020. February and March was the beginning and the explosion of COVID. So other events began to overtake the office very quickly.
All right, so far I like this
And
guy.
actually, in February,
I respect
as early
this
as
guy.
February of the COVID year, 2020, before everything really
He's like,
breaks out,
he's done his due diligence.
March.
He's looked at it every
You
possible way. He has
yourself,
an opinion.
Give talks.
He talks it over. He's of the opinion, and he gives his best legal advice.
A huge
I respect
issue,
that.
particularly as it affected the legal things that the AG's office was going to have to get involved in.
Yes, we, even before March, when COVID became a reality for most Americans, we were wargaming, planning, having internal meetings about what the potential legal effect would be if a pandemic were declared and COVID hit our state.
Did the Attorney General's office have a position from the very beginning, initiated and urged by the Attorney General, as to what y'all's legal position was going to be in dealing with the COVID plague, in the issues of whether it's masks or whether it's meetings, whether it's gatherings, whether it's activities? What was his position that each of you were challenged to carry out?
Yes. The situation was very fluid in March. I would say we didn't have a position per se, but very quickly over time, as states began shutting down, canceling school, mask mandates were imposed, stay-at-home orders were imposed. Very quickly, it became the policy of our office, and I would argue the policy of the state of Texas, to do everything we could to keep things open as much as humanly possible, consistent with public safety.
Counselor, I went a little past our break, I promised, for everyone involved. Is this fine?
This is fine. This is perfect.
We'll break till 20 after, take a little bit, it's a 20-minute break, 10 after, 20-minute break, 10 minutes after, 20-minute break, get a snack, and then we'll go to about 6:30. We'll go another hour when we come back.
Thank you.
All right. Okay, yeah. So far, I like this guy. I like what he says, and I respect this. I respect this role very much. And I've sort of had this fight as well before in my own sort of world. It's like, look, I'm a professional. I'm a lawyer. I'm a professional. You were hiring me to do a job. Like, I'm going to do the job to the best of my ability. I'm going to come up with the opinion I have. If you have a different opinion, I'll try to look at it different ways. But at the end of the day, I can only sort of see it, how I see it. I'm not going to corrupt my view, for the sake of expediency. If you want to, do something else, if you want to overrule me, whatever, I understand. But this is my view. And so I'm not going to, give my signature to something, if I don't agree with it, because I don't agree with it, so it's and I respect this. I respect this, right? The Attorney General wants something. I look at it every possible way. It's like, I can't do it, boss. I can't do it, consistent with the law, consistent with our precedent, consistent with all these things. It's like, I'm looking at this every possible way. Is there any way we can do it? No way I can find to do it. Can't be done. It's like, can the Attorney General do it directly? Yeah, probably. But, it's like, if you want my acquiescence, I can't give it. So far, I respect this. I respect this. I respect this. And, you gotta just be like, this is what I think. And to some degree, this also can remind you a little bit about how courts work as too, because of course, courts have dissent. Sometimes you get 8-to-1 opinions, and sometimes the one guy's right. Morrison v. Olson, of course, being the most famous example, perhaps, where Justice Scalia wrote what was called the Great Dissent, because not only was it one of the greatest opinions Scalia wrote, but also wound up becoming the law. So the one man minority opinion who can't be convinced. Sometimes, that's the right answer. Or at least, my girl Sotomayor in Kansas v. Glover. It's okay. It's me and Sotomayor in a raft alone. We'll get there eventually, Sotomayor, you and I. It's okay. In our 8-1 descents. All right. Anyway, so we just see it how we see it, and we call it from there. So fine. So yeah. Gift sent at convenience. Now's a good time. Let's read some gifts. We like gifts. We like gifts. It's good stuff. We like gifts. Good things for all. Stony Bleeds gave $1.99. Say sorry, Kurt, won't happen again. Don't worry about it. It's fine. No big deal. Chris Branson became a uncivilian for 99 cents. Thank you. Jay Pena lost his power wishing his scope of office, not for ultra-virus acts. Fair. Ninja Vesto says it's coming from the UK. How do impeachment trials work? Well, the impeachment trial process works pretty simply. Well, in the U.S., in the House, the House decides to impeach. The Senate decides to convict. They need 2/3 of them to agree. They agree on basically any basis they want. So it would be, I don't know, roughly equivalent to the House of Commons. Well, you guys elect your cabinets from members within the House. So that the analogy doesn't work. Do you guys have any officials outside of that? I don't know. It would be roughly equivalent to the House of Commons having a vote to decide to expel somebody because reasons. I assume that's the thing the House of Commons can do. So, yeah, anyways, that's the rules are made up and the points don't matter. Whatever they kind of agree to, because it's fundamentally political in its nature. So they need the House to impeach and the Senate to convict. So the House voted 121 to 23. So, kind of an overwhelming vote, and we need 21 votes here to convict. So we'll see. Who do I think is winning so far? So far, Paxton is winning, but I'm keeping myself an open mind because I'm willing to hear more. So, yeah. Dennis Daly became a member for 99 cents. Matthew Harris became a 99-cent uncivilian. Don't break the bank, Matthew, by becoming a larger supporter than that. Aston Pro Courier and Apostle gave $10 to say my commentary rock, and that was their first super chat ever. Exciting. I'm theoretically supposed to go to stand-up class tonight. I don't know if I want to go. They can't make me. All right, we'll see. I don't like having any material. Yeah. Oh, and in terms of what happens if the Senate votes to convict, he loses his job, and then they can also disqualify him from ever holding office again for any elected office in Texas. So that's the consequences portion of this. So if they vote to convict, he loses his job, and they can also DQ him from ever holding office again. Audra gifted 5 gift memberships. Matt asked how the trial's going. It's all right. So far, so good. We'll see. How many people are watching? I have it over here somewhere. 549 of you currently watching. Thank you very much to the 549 of you currently watching. Just a friendly reminder, of course, as always, to hit that subscribe button if you haven't already. And we will be on, of course, tomorrow morning, bright and early, with more of whatever this is. So this is exciting. We're looking forward to several more days of this. Matthew says he'd still be able to hold federal office. That's correct. He'd also be able to hold office in any state other than Texas. Texas can only disqualify him for Texas. So maybe he can be AG somewhere else. What are they impeaching him about? Well, the story is that he used his office to benefit a guy named Mr. Paul, who was a real estate developer, and that he, for various reasons, wanted to help Mr. Paul. So he used the apparatuses of his office for corrupt purpose. And, tried to cover it up and stuff like that. That's basically the bottom line. They were referring to this, Attorney General's opinion that he wrote, but it says it's not an Attorney General's opinion, so there's that he tried to, corruptly, whatever. Has Greg Abbott ever given an opinion about the impeachment of Paxton? Not to the best of my knowledge, no. Also, there was a home renovation allegation. Well, I don't know if he did it to get his home renovated. I don't know if they stated that was his motivation. That was one of the allegations, that he got that as part of the quid pro quo of their relationship. But I don't believe they alleged that he did it in order to get the renovation. Although maybe. But that wasn't my understanding. I don't know that they stated a motivation. So maybe I missed a memo. Jason says, I agree the AG is doing better. Sadly, in politics, the votes are already counted. That's what I do as a lobbyist. Yeah, I mean, possibly. Quite possibly. I don't know. I'm just trying to assess for whatever I think. So I'll try to give you one honest man's opinion, or at least attempt to. I'll try to give you at least one honest man's opinion about what I think. And based on the standards that I'm supposed to reach. So, there is some evidence. I have an open mind. I'm a long way from reaching any conclusions. Quid pro amateur. That's nice. I like that. It's fun. I just want to try to reach the right conclusion as best as one man can based on all the facts. I just want all the facts and try to reach the right legal conclusion and try to think it all the way through as best as I can and just try to be like, well, here's what I think. Here's what I think. Here's all the information I have. Here's the law as best as I can understand it. Let me try to reach the best conclusion. Like a good jurist or something. Sandy said, for $10 on a point scale, 1 to 10, House made 0 towards proving opening statement. I don't know about that. Paxton made progress on mobile front. When Paxton hits 1, it'll be more like 5. Underlying groundwork effective today. Perhaps, quite possibly. And thank you very much for that first super chat, Sandy. That's very kind of you. I think that there is some evidence that things were abnormal in the AG's office. I think that the most favorable interpretation of the evidence in favor of the prosecution is that the AG was doing things out of the norm in a way that would apparently benefit Paul. That's the sort of the, yeah, but yeah, I would like more evidence towards that conclusion before I'm ready to say that I'm convinced beyond a reasonable doubt of anything. But we'll see. And also, of course, as we've noted, Paxton lawyers have done fantastic work making the first witness look like an idiot. And also getting him to openly confess to things that could quite possibly be criminal, even though he doesn't seem to notice. Which seems odd, but okay. $5 from Pineapple Prime, who says, let's go Paxton. Well, let justice be done is what I will say in response. right? Let justice be done. In order for us to decide whether the verdict they come to is a just or unjust conclusion, let's pay attention. Let's try to assess the facts. Wouldn't that be fun if we did that? Wouldn't it be fun if we looked at the information and tried to assess it based on a reasonable understanding of the facts as presented? That might be fun. And then, whichever side I wind up ruling for, the other side can accuse me of being a biased shill, whatever. Biased shill, rhino, Trump heart, or whatever it is I am that day. Am I a rhino, Trump hard, ultra con, MAGA, neocon? Depends who's disagreeing with me that day. Depends who's disagreeing with me that day. Good times. For whatever value it is, I consider myself Republican. I'm not sure how much value that has in this exchange, but there we are. I consider myself conservative, although on a 1 to 10 scale, I'd probably consider myself more along the lines of maybe a 7 or 8. I wouldn't necessarily consider myself ultra 10 because I still have a brain. Lol. So maybe an 8 out of 10. But, I am, for example, willing to disagree with people because I think it's right. So maybe 8 out of 10, maybe 7. You guys can figure it out for yourself. I don't know. Probably not going to be the next nominee for anything from any of the Republican Party, because I'm probably not far enough right for their taste, which is annoying. But what can you do? Thank you, No Pants Baby, for saying I'm based. That's kind. Let's just put on our thinking brains and try as best I always try to look for a consistent framework, right? Because I like rules and process. They say I'm type C kind of guy. So fine, I'm a type C kind of guy. I like rules, process, order, structure, and I like things to coexist in a nice framework that makes everything work in a consistent, holistic way. That's sort of the goal. And I need a nap. What happened to my hand? Sometimes it just hurts. I just have it in a removable hand brace. Sometimes my wrist and hand hurts. So when it does, I just put it into this little sports brace to make it feel a little better. So, just to prevent it from flexing. Too much keyboard typing or mouse movement, I don't know. Matthew says, I'm definitely not getting a nomination anytime soon because I just finished suing a representative in a really public fight. Yeah. Yeah. So I'm fine. I'm fine. I'm not going to get my gym time in today, which really bums me out. It's already 5 o'clock, and they're supposed to go to 6:30. I'm not going to make my stand up tonight. I'm not going to make it because they're going to be too late. I won't be able to get there in time unless I walk in like 15 minutes late. I might have to like run out the door because it's on the other side of town. It'll take me a good half hour to get there. So I'll be like 10 minutes late. Oh, well. Yeah, so for those of you who are curious about such things, I've been doing improv classes for quite a while. And I decided to take stand-up comedy classes because I thought that might be good for my YouTube and such. So on the plus side, once again, business expense, because I'm using the stand-up classes to help make my presentation, better, so that I'll be able to, use elements from stand-up comedy towards my presentation. But so far it's been write stand-up comedy. And I was like, but how? And they're like, but do it. And I'm like, how? I don't get it. So, we're working on it. We're working on it. Toastmasters, I've done Toastmasters before. I used to be a area governor for Toastmasters. I've definitely done Toastmasters before. It's fantastic for public speaking. Recommended. Yeah. I've been club president. I've been area governor. I've won a few area competitions before for public speaking. I've won area before. I've never won division before. Because then you'd go on to like internationals. I came close once. I think I came in second place one time at division. But, yeah. $10 from Sandy says, can you give your opinion on the gag order? Yes. So for those of you who don't know, the Senate, as part of the rules, passed a gag order that prevents the senators from talking to people about this issue while they're deliberating. So I think it presents serious First Amendment problems, both from a freedom of speech standpoint for the senators and even perhaps more importantly from a position of redress of grievances. But they say that they're acting as a jury, and the Texas Supreme Court, in their wisdom, decided not to decide the issue. So, yeah, that's where we are. You won first place in your 6th grade talent show. I never actually finished my CTM, ironically enough. Or DTM it would be, I think, for the upper level. I've never finished it, actually. I'm still in the old system, under the old Toastmaster system. I was like, I'd have to like look at, they changed the system in Toastmasters a couple years back, so I'd probably have to like redo the education plan completely. Which, fine. My brain hurts. You want to listen to some more stuff while we're waiting? Since I've answered all your questions. If you don't have questions, I'm reading more. In part, I said, Dear Honorable Justice Beatty, with all due respect, we have a limited amount of time when Judge Newman says break, and we are adjourned for an hour and 15 minutes. I'm responsible for feeding 18 jurors, 4 bailiffs who watch over the jury, Judge Newman, his wife, his law clerk, his law enforcement detail, my 3 staff in the courtroom, me, my 2 court reporters, a media attorney who's here requested by the judge, 4 law enforcement who are security for the courtroom, the defendant and his 2 guards, court administration staff who is here, and an IT specialist who has been contracted in for the trial. This kind of trial and its process is large, and quite frankly a new experience for us on this scale. I'm doing my best, I know, in taking care in spending the taxpayer dollars in the use of my budget to the best of my knowledge. If someone else would like to come in and take over, they are welcome to. I will hand over the accounts, the whole trial, the decision-making process that comes with it, the complaints from the public, the media, my own county, many of my staff, and I will gladly sit back and take a back seat while someone with a much brighter mind takes the reins. This is the clerk of court writing the Chief Justice of the Supreme Court of the state. Just, FYI. So, yeah. The clerk of court could be a little bit nicer in their tone. Just saying. Okay. As I reread the email, I realize that I could have been replaced immediately. Chief Justice Beatty, who's quite wise in his ways, having much experience in education, was very understanding of the situation, and I was allowed to continue. After I cooled down, I apologized in person to the person who questioned my integrity with the original email. I received a very nice reply and a phone call from the Chief Justice, who validated my feelings. Wow. Then we moved on. We eventually ended up serving closer to 60 meals a day, and I believe it was a worthwhile expense. Kudos to my deputy clerk of court, Laura Cloud Hayes, who at this point is like, don't mention me, who took on the task of ordering the meals every day, making sure every meal was correct, while lining up everything each step of the way. Chief Justice Beatty and I bumped into each other in the Clerks of Court conference in Myrtle Beach, and remembered him calling him, and he remembered me calling him during the trial of the century. He was very graceful and kind to me. He was even supportive of me writing this book and gave his blessing. Did he? Did he know what you were going to write? Would the Chief Justice of South Carolina like to have a word about this? You just threw the Chief Justice of the state under the bus in your book. That's just fantastic work. That's great. That's really sharp. He might be rethinking that position. Not only was I an attendee at the conference this year, but I was also the one in speakers. I took the podium with the founder of Fitz News, Will Fuchs, who was the investigative news organizer that covered the Murdaugh stories online and via podcasts. He talked about the journalism side.
To order. Mr. Hardin will go to try to wrap by about 6:30. If a good breaking point, if it's a few minutes later, fine. If it's a few minutes sooner, I'll leave it to you.
All right, I guess that's the end of reading time. I know you're saddened. I know you're heartbroken.
There you go. Thank you.
We'll wait for our witness here.
The necessary participant. Now, if you can keep the microphone to you, my problem is I can hear you sometimes thinking, so I think you're perfect where you are. All right, we move on now from the open records. Does it, in your mind, is so the issue die out as to that file after your conversations, repeated conversations with the AG? Oops. Is that got a button?
Testing.
Yes.
Yes, the issue did eventually, from my perspective, die out. It was not raised again for some time, for a matter of months after that.
Did it resurface later that year?
It did.
And how and when?
And once we finish her book, we always do have the words of Chad Daybell.
2020.
Don't
as
forget,
COVID
I've got
was
like 6
kicking
books by
in,
Chad
I was
Daybell. Would you like to read one of those?
Deputy First Assistant Attorney General. So the role that Brantley Starr previously had, he had been elevated to the federal bench, and I was asked to assume that role. So Ryan Vassar became the Deputy for Legal Counsel, which was the role that I previously had been serving in. But I was aware, because I was working with Ryan Vassar at the time, helping him to learn the ropes of open records, that another request had been submitted, this time to DPS.
Stacy, can you pull up back the first demonstrative we started the trial with that lays out the pictures of everybody? Thank you. Can you see that okay?
Yes, sir.
Can you see that okay? So, does that accurately reflect where you were in the new lineup?
Yes, it does.
All right, I'm going to call this demonstrative 1. And this particular document, whom did you report to?
I'm not seeing a lot of support in chat for Chad Daybell, I have to say.
To Mr. Mateer?
I reported directly to Mr. Mateer.
And then how many divisions did you have under you by this time?
I was still overseeing the Special Litigation Unit, but apart from that, I had no other direct reports. However, as the Deputy First Assistant, I was assisting the First Assistant in overseeing the agency as a whole.
So if the First Assistant was out of town, would you be the one that would be essentially the acting First Assistant?
More or less. When he was out of town, I would assume some of his responsibilities as a matter of practice. I also would handle duties as assigned by both the First Assistant and the Attorney General.
And you by this time had known Mr. Mateer how long?
Several years.
All right. Had you ever seen or known him to express any interest in ever being the Attorney General himself?
No, I had not.
All right. On a scale of 1 to 10, 10 being totally absurd, 1 being much less than that, where would you rank?
In terms of his desire to become the Attorney General,
yeah.
He was very tired. By the end of his 5th, he was going into his 6th year, and he had expressed to me, especially toward the end, how he was thinking about retiring from public service because his back was bad. He had been burning the candle at both ends for some time.
So on a scale of 1 to 10 again, in terms of his desire, your observations to be the Attorney General, where would you rank it?
It would be 0.
All right. Thank you. Now, let me ask you this. How did the continued issue of the open records request and desire to obtain open records concerning Mr. Paul's search warrant and criminal investigations again, how did you next come into contact with it and when?
Speaking with Ryan Vassar, who by that time, April,
also, I have to
May
say, I do like this guy's
2020,
voice.
He was overseeing open records as the Deputy for Legal Counsel. I understood that a request had been filed, I believe it was with DPS, for additional materials relating to the Nate Paul investigation.
All right. And the original time that you became aware of Mr. Paul seeking these records, whom was the open records request directed to, if you recall?
My recollection is the State Securities Board the first time around.
So that one went off as you have described in your testimony. And then did you learn that there had been a second open records request, this time to another agency that was present in the search, this time DPS?
Yes.
All right. Had you had conversations in the past in which the Lieutenant Governor expressed his views of DPS?
Excuse me, I think you mean the Attorney General?
Pardon me,
You said the Lieutenant Governor? I am listening very closely, Counselor.
That was only to see if you were paying attention, sir.
Trust me, I'm not missing a word.
Now that you've confirmed that you were, let me rephrase it. The DPS, I'm a little flustered here. I'm going to have to recover. So would this then, the second agency that had been involved in the search of Mr. Paul's house and business back in August of 19, was this now the second agency Mr. Paul and whomever is working on his behalf tried to get documents from?
That is my understanding. I was aware that this was the second time. I do not believe Meadows Collier was involved this time around. A new law firm had surfaced.
Yes. And do you recall whether the name of that lawyer?
I believe it was Gregor Wynn.
And was the lawyer you were dealing with, Mr. Michael Wynn?
He was part of that firm, to my recollection, yes.
Now, so how did it come to your attention as to what you were supposed to do, or what you were regarding, rather?
My understanding was this request was again for law enforcement materials, this time in the possession of DPS, not SSB. But again, these were all agencies part of this joint law enforcement operation. So very similar materials were being requested, again, relating to Nate Paul.
So how did you get dragged into it as to your position and your participation?
Primarily by assisting Mr. Vassar, who was at that time very, very new to the role.
All right. Can you describe for the jury the sequence of events as it was being considered in the Attorney General's office to override past decisions on these same matters?
Objection to leading, Your Honor.
I don't.
Sustain, rephrase.
Let me put it this way. What happened next?
Many things. So this request was submitted to DPS. DPS then did what it normally would have done, which is request a ruling from our office, from the Open Records Division, which was per normal process. At this point, the Attorney General became interested in the file once again.
And how did he show that interest?
He asked to meet with Justin Gordon. I believe it was at this point where Justin Gordon was summoned to the Attorney General's office to have discussions with the Attorney General about this file. And he also asked for a copy of a book that we keep in our office. We have a manual that we publish. When I say we, the Attorney General's office, every 2 years, I believe, publishes an update to the Open Records Manual to reflect changes to the code from the previous legislative session.
Did you provide him the book yourself?
It was either I or Ryan Vassar. I do recall we were looking for a copy in the office because he wanted a paper copy. Right. And the copies we had, the pages were falling out, so we had to go make sure they were all there.
Now, did you begin to continue to have repeated conversations with the...
Objection to leading.
I don't think that's leading at all. I haven't even finished, by the way.
Your Honor,
it works better if I finish the question.
Finish the question first.
Thank you very much. Did you have any continued conversations with the Attorney General about this matter?
My conversations were primarily with Ryan Vassar and Justin Gordon at this point, assisting them in handling it. I did overhear conversations. I know I did see and witness the Attorney General pull Justin Gordon into his office concerning this matter. So I was keenly aware, being on the 8th floor and working with my colleagues, that this was happening.
Did the Attorney General himself contact you about his interest in trying?
All right, guys, I'm going to impose on you a little in chat. I know you guys are down for it. I want to get the Twitter for tomorrow going, so I'm about to spam the chat with the link.
Then did you have any participation?
So if you could click on that and retweet that for tomorrow,
of what happened,
I would appreciate it. Thank you very much.
In the realm of Mr. Vassar.
I did have some observations, and I did have some participation in what happened next.
In what way? What was it?
There were a couple of options on the table for how to handle this open records request.
I'm not bound by either the time limits or the fact of posting URLs. I have unlimited power.
Or you sustain the agency's request for exemptions. It was clear to us that the Attorney General was now stridently in favor of finding a way to disclose this information.
Objection to speculation.
Were you aware of what his position was?
Yes, I was personally aware of his position on this.
How were you personally aware?
Because I was in the office. I watched him as he was conducting himself. I overheard conversations of which he was a party concerning this. So yes, I was aware based on my interactions with him.
And how would
Judge, I'd renew my objection to speculation.
I think these are all party admissions, every single one of them, Your Honor. I mean,
I'm sorry.
These are conversations.
I did not hear you.
I'll wait and let him ask the question. Okay. I'll retract my objection.
Continue.
So then, when you heard those conversations, what did you hear the Attorney General say? And who was he talking to?
Well, there were always groups of us on the 8th floor. It's very hard to hide on the 8th floor. It's a very small floor, and it's a square or a rectangle. And so there's not a lot of, and my office was directly down the hall from his. So I was very close to his office. And the summary of it was, he was desirous of finding a way to either disclose that information or at the very least, not rule against the requester.
What was the recommendation that you were aware of all the deputy in charge and the people above him, below him? What was their recommendation as to what should be done with the request of
Objection to hearsay.
I was
Objection.
Sustained.
Were you present when they made their recommendation to the Attorney General?
I was personally involved in formulating a recommendation, yes.
All right. Did you yourself make a recommendation to the Attorney General?
I do not recall if I made the recommendation, but I certainly helped my colleagues
Objection and
formulate it.
non-responsive.
Wait a second, you've got to let him finish the answer.
I'm making an objection.
Do that.
I'm objecting.
Stop. Please stop.
I had an objection.
No arguing. What was your objection?
My objection was that this witness answered counsel's question, and then the latter half of his answer was not responsive. And so my objection is not responsive, Your Honor.
The objection.
Overruled. Continue.
Thank you. Go ahead. I think my question to you was, did you yourself make a recommendation to the Attorney General, or were you present when others made a recommendation to the Attorney General to where you could hear his response?
No.
All right. Did you have any conversations with the Attorney General after the period of time we're talking about?
Concerning this matter?
Yes.
Not to my recollection.
All right. At the time, were you present when the decision was made that it would take no position?
I was directly involved in that decision.
And tell us about that and how that happened.
Certainly. We were evaluating options for responding to this open records request. It would have been, in my view, unconscionable to do a pour out. For all the reasons we discussed, the law enforcement exception has very strong public policy grounding in this state. The Attorney General, based on my involvement in this case, I knew was not going to tolerate anything
Objection
less
and
than...
non-responsive, Your Honor.
It is responsive. Excuse me. I think he's just finished.
Move along.
Objection is, okay.
Go ahead.
I understood that he was not going to tolerate anything that was viewed as unfavorable to the requester. As a result of that, an option was developed to do a no decision or a no opinion, which was very unusual.
Do you recall who came up with that option for him?
It was a group of us, Justin Gordon, Ryan Vassar, and myself. In conversations, that opinion was ultimately, that approach was reached.
And what was your position as to whether or not the no opinion option was one that should be adopted?
I believed it was the wrong approach. I believe it was the wrong decision, but it was the best we could do given the place that the Attorney General was at the time.
And was that adopted to keep him from continuing to insist on the other? In other words, continuing to insist on disclosure?
It was the best answer we could reach that we knew would be accepted by the Attorney General at the time, even though I believed it was wrong.
Now, it's been suggested in this litigation the last day and a half that meant no harm was done, no benefit was given to Nate Paul by that. Do you agree with that?
No.
Why not?
Objection is speculation, Judge.
That's not speculation.
Overruled.
Yeah, thank you.
There was at that time pending litigation concerning the open records request. We were being asked at the same time to issue a ruling on that request. It was my view that the ruling should have denied access to those records. That at least would have been persuasive authority for the court that was examining that very same issue. We had a policy at the AG's office that we would not withhold making a decision based on pending litigation. So, in effect, our no decision contravened our existing policy.
And in addition, did it provide any advantage, in the potential advantage to the litigant, Mr. Paul, even though you weren't recommending disclosure, by recommending no opinion, do you have any idea as to whether or not that still conferred a benefit on him?
Yes.
And what was the benefit?
As a logical inference, anytime our office is the authority on open records decisions, if our office refuses to take a position, which, by the way, is deeply out of character and contrary to our precedent.
Objection and non-responsive, Your Honor.
Let him finish the answer, then you can object.
Continue, you may answer.
If our office refuses to take a position on an issue like that and the court sees that, that is a strong signal, I believe, to the court. And I've been a lawyer for over a decade, probably close to 2. That's a strong signal to the court about the Attorney General's view of that file, that we would have gone out of our way to render a vastly uncharacteristic decision.
Okay. Now, after that happened and that no opinion about it occurred, did you have any more contact with the open records request that Mr. Paul was making?
Once the no decision was issued, no.
All right. And then what was the next contact you had with matters of Mr. Paul?
It was in June, I believe it was in June, it may have been in May, but it was in that time period, late May, early June 2020. The Attorney General approached me personally and asked me to review a file that was, it was a lawsuit that was pending between a charity, the Mitty Foundation, and World Class Holdings, which I very quickly recognized as one of Nate Paul's company.
Had you had a history, even your previous jobs or even this one, overseeing the AG's position, the office's position of charity trust?
Yes.
Would you tell us what basically, by both statute and mission, was the obligation of the Attorney General's office as it involved charity trust?
Generally speaking, and this is true for most attorneys general's offices that have this jurisdiction, you are there as the Attorney General to protect the public interest in charity, which means that the public has an interest in ensuring that charities that are formed pursuant to state law are fulfilling their function to benefit the public interest, meaning the corpus of the proceeds the charity manages and operates on are not being squandered or wasted, that the charity is not being hijacked for improper purposes, and that is generally
Uncivil needs a break.
Its role.
Don't panic. Uncivil will return. Talk amongst yourselves.
Role is to intervene in lawsuits, to participate. And by the way, we have authority to investigate charities that are abusing their role. The Attorney General's office protects the public interest in charity.
Is under the law and the responsibility and the mission of the Attorney General's office, is the Attorney General's office in a charity trust case supposed to be intervening in any way to help one individual or the other?
The Attorney General's office is to intervene to advance the public interest in charity. So it is not characteristic to intervene to assist a party in particular. Rather, the intervention is for the purpose of defending, protecting, and ensuring the public interest in charity.
So if, in fact, a set of facts or course of conduct in making the decision to intervene would benefit the opposing party in the litigation to the charity trust, what would you expect the position of the Attorney General's office to be?
Under that hypothetical, if we were being asked to intervene to aid a party that was actively seeking to harm a charity, we should not intervene under those circumstances.
Well, in the case were you aware, did you become aware of the Mitty Foundation?
Again, I did become aware of the Mitty Foundation. The Attorney General personally brought the issue to my attention.
And when did the Attorney General bring that matter to your attention?
It was either toward the end of May or the beginning of June. It was sometime in that time frame.
How did it happen that he brought it to your attention?
He asked me to review the file and consider whether or not there was a basis for our office to intervene in the litigation pursuant to our statutory authority.
Is that the third time you've now been asked within 6 months to review a matter that involved Nate Paul?
Yes, yes.
So at this time, how would you characterize your feelings about whether or not the AG's office ought to be getting involved in anything that involved Nate Paul?
My feelings were that I was becoming increasingly concerned because the initial foray into the world of Nate Paul was through the Open Records Division. That had ended with the issuance of an uncharacteristic opinion. And now it had, in my view, metastasized to a new section within the Attorney General's office that had nothing to do with open records. This was a completely new front It had nothing to do, by the way, it had nothing to do with the criminal investigation.
Objection to narrative and non-responsive.
I'll ask him another question.
I sustain the objection.
Thank you. When you were asked to look at this, where and when was that?
Early June.
And how and where did it occur?
In the office on the 8th floor.
And who was present for the conversation?
Based on my best recollection, it was just the two of us. I believe it happened in my office on the 8th floor.
When the Attorney General came into your office, what did he say and what did he want?
He wanted me to review the litigation file and evaluate whether or not there was a basis under our statutory authority to intervene.
At that time, had you personally met Mr. Paul yet?
No.
And so how long did this conversation with the Attorney General who asked you to look at the file take?
My recollection is it was very brief. I got the name of the case file from him, just the basic identifying details so that I could locate it, and then after that, he left.
All right. Did you, once you got the file, did you review it?
I reached out to a gentleman named Joshua Godby, who at the time oversaw our financial litigation division. I wanted him to at least help me evaluate this request because it was his division that had primary responsibility for deciding whether or not to intervene.
Did the Attorney General tell you what he wanted you to do at this time?
Beyond just the desire to review the file to consider intervention, no. It was very straightforward. Consider this for intervention.
How long did you talk to Mr. Godby, and afterwards did you review any materials, or did you stop at your conversation with Mr. Godby?
I asked Mr. Godby to provide me background on the case. I learned through those interactions that we had actually waived on the case months before.
All right, so at that time you became aware that y'all had taken a position previously not to intervene in the lawsuit?
That is what waiver means.
My eyes are hurting a little bit,
notice
people,
is sent
so
to our office.
sorry we have to do this
there's
because
a charity
from time to
involved
time
in
my eyes
litigation,
get a little
they're required to
sensitive.
notify our
So it's
office
time
of
for
that and give
Uncivil
us an opportunity to
Sunglass
intervene. We
Hour.
received that notice and we had issued a declination of waiver.
In your conversations and research, did you discover when it was chronologically that the office had previously declined to enter the litigation at all?
My recollection, it was early in 2020, perhaps as early as January.
All right. And so after that declination, what did you learn? What was the occasion for this issue coming back before you?
My impression was it was the Attorney General asking me to review the file. And
at that time, did you discover how long the litigation between Mr. Paul's companies, therefore Mr. Paul, and the Media Foundation, how long had they been in litigation by that time?
It had been a long and sordid affair, yes. Lots of litigation had taken place.
And was it more than 1 year?
No Pants Baby says I recommend eye drops. I really do not like eye drops. I never have liked eye drops.
The case file was well developed.
All right.
We'll try a different solution.
Once you talk to him and once you talk to Mr. Godby and you reviewed your other materials, what'd you do next?
Well, I notified the Attorney General that we had waived. We had previously waived on the file.
And did you have a recommendation as to whether you continued that waiver?
Either at that time or subsequent to that, I did. I had looked at the file. My strong belief, and by the way, this is very common, we rarely intervene because oftentimes the factors for intervention
Objection
are not met.
non-responsive.
Let me ask you.
These are not Oakleys. These are Maui Gems.
What was your opinion after you talked to Mr. Godby and looked under the circumstances? By the time you talked to the Attorney General, what was your opinion as to what you should do?
There was no basis for us to intervene in the case.
Did you have that recommendation to the lieutenant? I mean, did you have that?
I would object again.
I'm not
here.
suicidal, Your Honor. I'm not, I promise.
What?
Did you have that? Did
Sorry,
you share
what now?
that opinion with the Attorney General?
My recollection, yes, I did share with him what had happened. The waiver had been filed, and the reason for the waiver was there was no basis for us to intervene.
What was the Attorney General's reaction?
He was not happy with that response.
How did he show he wasn't happy?
He informed me that he was surprised and not happy that we had waived. He wanted me to reconsider the waiver. He informed me that, in his view, it was improper for a charity to be oppressing a business, especially when the charity was effectively a limited investor in the business. He thought that was out of bounds for a charity to do that.
Bev D asked, did you turn nightlight on your PC? It wouldn't do me very much good. The problem is the key light that's shining directly into my eye so that my face will be well illuminated.
On one litigant against the other in the case?
So dark mode on my PC is not going to have much of an effect compared to the big light.
Was doing wrong to the world class.
And did he express any kind of feelings of himself against Mr. Godby's thus far resistance to entering the litigation?
Yes, Mr. Godby was resistant to entering into litigation. He and I had many conversations to that effect. We were both in agreement that intervening would have been was a poor choice and was not justified by the circumstances.
It was the position that made its way to the Attorney General.
Yes.
How would you describe why you and Mr. Godby had concluded that you should not change the earlier decision and should not intervene in the lawsuit?
The charity was represented by competent and able counsel. It was taking legal positions that we believe were justifiable. It was largely, from our view, doing well in the litigation. The litigation involved a request for World Class to produce books and records concerning the investments the charity had made, and World Class was refusing to provide those, which any good corporate lawyer knows is improper. And so the charity was defending its interest in its investment aggressively and appropriately.
And was the charity itself simply seeking to find out what the value of their investment was?
Yes. Among other things, yes.
And among that and others. And whatever expenses had been incurred, when y'all looked at the file, who was causing the expenses?
The litigation had, when I earlier said,
I'll just have to sit here being the coolest lawyer on stream.
World Class was rapidly burning
because I have cool glasses.
It had developed a history of using law firms,
we'll just have to deal with
not
my
paying their
radness.
bills, cutting them loose, going on to the next law firm. So it was using law firms at a frightening rate. It was filing a number of motions. It was resisting discovery into its books and records.
Objection or non-responsive?
No, it is responsive. That's exactly what I'm asking. What was happening with the assets, and so, and which one of these two parties was causing the expenses?
To our witness, just try to answer the questions directly moving forward.
That's right.
All right. Now, at the end of the day, what would you describe the dispute being a minority investor invested with a company, Mr. Paul's companies, and they can't get any records, books or records to tell them what the expenses are, what the value is or so. And so there's a lawsuit. Is that a fair resolution? Fair description?
Looks like I have special
that is my
needs.
understanding of the basis for the lawsuit,
All right.
yes.
And so when all this was going on,
Looks like I'm wearing glasses for the blind.
The Attorney General that you and Mr. Godby,
I could do worse, I suppose. I mean, there are some blind lawyers out there, so you know.
What happened?
I'll join the blind lawyer crew.
He directed us to intervene.
He instructed y'all to?
Yes.
So did he interfere in a lawsuit? Did that ultimately turn out to be on the side and effect of Mr. Paul?
Objection to leading.
How did it
Sustained.
All right. How did it end up? I mean, was there anybody that benefited from that by the fact that the Attorney General's office came in?
You never seen a blind YouTuber before?
An improper opinion, Your Honor.
Oh, I have.
Sustained.
Well, you clearly, though, knew what the result was going to be.
I'm trying to think.
Objection to improper opinion and speculation.
But yeah, I've definitely seen blind. I've seen blind YouTubers before.
Thank you. When you were opposed to the intervention, whom did you believe would benefit from the intervention?
Objection to speculation and improper opinion.
I've asked what his opinion is. That's very relevant here.
And I'm objecting to the opinion.
Excuse me.
Overruled.
Thank you. Whom did you believe would benefit from the intervention?
It was clear to me that the intervention.
Keep your microphone, please.
It was clear to me the intervention would benefit world-class holdings in Nate Paul.
All right.
There was no question about that.
And what was your position expressed to the Attorney General as to whether that was appropriate or not?
It was not appropriate.
All right. In spite of that, there was an intervention?
There was an intervention. I was directed.
Maybe I'll
by the
tell
Attorney General
YouTube that
to
I'm
do so.
blind.
I instructed Judge
And they'll
Godby
promote
to
my
make
channel.
the intervention. We justified
That'd be
it
good.
on the basis that we would intervene for the purpose of bringing the parties together for a mediation. That's honestly how I put lipstick on that pig.
What was your knowledge as to where there'd already been one mediation that was unsuccessful?
Yes, there had been.
Had there been an agreement previously?
Yes.
And do you remember how much at that mediation that there was an agreement for that the Mitty Foundation would receive?
Yes.
How much was that?
My recollection was around $10 million.
And then was that agreement breached?
Yes.
By whom?
World class.
And by the time that you
I've even heard of blind trial lawyers.
Instructed and ordered to intervene, what was the status of the litigation?
That's badass, man.
The Mitty Foundation
Blind
was
trial
pressing
lawyer?
my
That'd be
Based
fun.
on my recollection, they were pressing
point me in the
hard for
general direction of the
discovery
jury?
into world class, and world class was approaching a point where they were
could be interesting.
risking sanctions for discovery non-compliance.
What was your experience both then and later that even has to do with this case? In terms of, was there a particular
I'd totally be a
consistent
blind
approach of
criminal
Mr.
defense
Paul
attorney. That'd be
whenever he got
great.
into civil
It's
litigation
like, well, it's hard for me
as
to
it
be
applied
biased.
to
I can't see
discovery?
my client.
He resisted it strongly based on what I could tell from the file.
All right. And so what did you do in terms of your position in the office after you were instructed to intervene?
I advised Mr. Godby of the decision to intervene in the case. The basis for that intervention would be to formulate a mediation to bring the parties back together again. Again, that was a post hoc rationalization. And we began speaking with the parties involved in the lawsuit.
Did you have any reason or belief that that was going to be successful?
No.
And ultimately, was it successful?
No.
And was there another final thing that you were instructed to do with the case that ended up with you being not involved any longer?
Following our intervention, Mr. Paxton, the Attorney General, asked if we could also file a motion to stay the proceedings.
Would that have stayed the discovery?
Yes.
And how was it that you knew that's what the Attorney General wanted to do?
He conveyed that to me himself.
What was your reaction?
I could see no justification for that. That would have been directly against the public interest in charity and directly for the benefit of only one party, world class.
Did you inform the Attorney General of that?
I told him that I was very uncomfortable filing a motion to stay and resisted it, yes.
So what was his reaction to that?
He was not pleased with that. I was subsequently removed from the file by Mr. Mateer.
And did without going into what he said, what was your understanding as to why you were no longer going to be there with the file?
My understanding was that Mr. Mateer believed that I was wasting time dealing with Nate Paul, and that I needed to stop wasting time dealing with matters concerning Nate Paul.
So then, after that, were you opposed to being removed from that file?
I was very happy to be removed from that file. I was quite frankly sick of dealing with Nate Paul.
Did you do anything like the equivalent of a high five or go out and visit, have a nice dinner or anything?
I was very relieved.
And so at the end of the time when you
He's not denying it.
Then,
He's not denying it.
Your professional career.
You might have had a drink at the corner bar, baby.
Having to do with Nate Paul.
I respect that, though. You can't hate the man for having a drink, being taken off a bad case.
So this is the summer
that's disrespect.
2020. We are still working around the clock on COVID matters, which was my primary focus. And in late July, again, Mr. McCarty and others had taken over the Mitty Foundation file. I was approached by the Attorney General again, this time to evaluate a matter related to COVID, and in particular the governor's order, GA, I believe it was GA 28, it was one of the closure orders, as it pertained to foreclosures of real estate.
Now, at this time, did you have any idea or any inclination at all that this also was going to involve Mr. Paul?
No.
Do you recall approximately when you say in the summer, I think you just said July now, because it's September and it's hard to tell this between July. Did you say July 31st, or was it earlier than that?
It was earlier in the week, yes.
All right, and how did the Attorney General contact you, and what did he want to know?
He came to me in person, and he asked me to evaluate whether or not foreclosure sales should be allowed or could be allowed to continue given the current state of the governor's COVID orders.
All right, so now we're in late July. The governor's orders roughly come out at the middle of March of that same year, correct?
And they were continuing to come out thereafter.
There would be periodic orders issued. Did the Attorney General express any interest in what he wanted to happen?
Not at first, no.
All right. So did you do anything in response to his immediate question?
I did not.
And why was that?
It was sort of an offhanded request, and we were busy dealing with a whole litany of matters related to COVID. It was also one of those sort of, hey, take a look at this type of requests. There was no real time frame associated with it, so I put it on my to-do list, but it didn't get high priority at that moment.
And then when was the next time he contacted you about it, if he did?
A few days later, he approached me and wanted to know if we had done the research and it was completed.
Do you recall which day of the week it was he approached you?
I believe it was Thursday. Yes, I believe it was that Thursday.
And what did you tell him?
I said no, it was not.
All right, so then did he say anything further?
Yes, he said, get on it. We need to get this done right away.
Did he express what he meant by right away?
He said this needs to happen within the next few days.
And that was on a Thursday?
Yes.
Well, the next few days takes into a weekend, right?
That's right.
Did he express why he needed something done that weekend?
He did.
What did he say?
He said that homeowners across Texas would benefit from an opinion dealing with foreclosures.
Now, you don't know anybody else is going to benefit from this. What was your reaction to that? Did you believe that it really was focusing on homeowners?
Overruled.
Objection. Okay.
Overruled. Answer the question.
I quite frankly wasn't quite sure what to think about it because I was scrambling to pull together the research. I had no basis to know whether or not homeowners would benefit or not.
All right. So did he provide you any evidence or anything to help you understand whether this was really about helping homeowners or not?
No, but he did. I did ask him directly if there was someone I could speak to who was cognizant of the issues or perhaps had even made the request.
What did he tell you?
We were standing in the hallway of the 8th floor.
He stopped you? What day?
This was Thursday, I believe.
All right.
Yes.
Go ahead.
We were standing out in the hallway, and I asked him if there was someone I could speak with who had knowledge of the request.
Now, let me stop you there. Let's explain to the jury as quickly as we can why that was relevant. What is the law that would require you to have some type of requester?
Well, the law, based on the Government Code 402, I think it's 045 or thereabouts, our office is not allowed to issue opinions to individuals unless those individuals are called out in the code specifically.
And did he give you any suggestion as to who was asking for this or who wanted it or anything?
He did. He went back to his office and returned in a few minutes and handed me a scrap of paper with a phone number on it.
And did it have a name as well as a phone number?
I can't recall, but I recall the phone number for sure.
So
if it was the name, it didn't ring a bell.
What did you do with his phone number?
I put it in my pocket. It was toward the end of the day, and committed to call the phone number that day.
What, on the way home or what?
It was late. We were pulling very late hours at that time because of COVID. So I do recall it was in my pocket. I was dealing with some other exigent circumstances, and I recall pulling into my driveway that evening. It was dark, so I got home very late.
So did you call this guy?
I did.
And tell us what happened.
Objection. To hearsay, this question calls for hearsay, Judge.
Well, actually, this isn't offered for the truth of the matter. This is simply an operative fact of this particular event, Your Honor.
That sounds like it's not offered for the truth of the matter. It's an operative fact.
Rephrase.
Did you call this guy?
I did.
And did he answer? Yes. And did you have a conversation?
Guys, it's not offered for the truth of the matter asserted. It's merely an operative fact.
We're calling about.
Objection to hearsay.
That is not hearsay.
He's backdooring hearsay, Your Honor.
Excuse me. It is not hearsay.
His question insinuates an answer from this individual, which would be hearsay,
It doesn't
Judge.
matter. Hearsay is a communication. This is whether he did not answer. I did not ask him if he communicated. Thank you. Well, did you find out whether this guy knew anything about it?
Objection, Your Honor, to hearsay. You sustain the objection.
Surely the question of did you find out whether this guy knew anything about it is not hearsay, in all due respect.
It's the same conversation, Your Honor. It's hearsay.
I haven't asked him, Your Honor, what the conversation was. I haven't asked him what the person said.
You could go either way on that one, I think. Judgment call.
Just answer yes or no to the question, not go into the contents of the conversation.
Could you please restate the question?
Did you find out whether he knew anything about the issue, basically, was the question. Doesn't have to be perfect.
I ask you, well, did you find out whether this guy knew anything about the matter that you were calling about?
Judge, I'd re-urge my objection that...
The judge has already ruled. Would you answer yes or no?
Judge, I'd re-urge the objection that it is hearsay. Anything...
He can answer yes or no.
Yes, Judge.
That's it.
I did learn whether or not this gentleman knew anything about the file.
All right. So as a result of what you learned from that conversation, did you go then back to the Attorney General? Or contact him one way or the other?
I returned to the Attorney General to seek additional assistance because I still had no assistance.
All right. And
who answered, if you know?
Tell the Attorney General, and what did he say to you?
Yeah, that might be hearsay, because how do you know who it is unless you recognize their voice?
He still did not have an authorized requester under the code.
Did you tell him
so if you recognize their voice, then fine. Otherwise, how do you know who it is?
Excuse me, let me be
This
heard.
question is...
Let me be heard,
the
please.
form of this question...
Stop arguing with each other.
Let me
Finish
be
your
heard,
objection.
please.
Your objection is?
The form of Mr. Hardin's question is hearsay. He is insinuating and stating hearsay in his question.
The difference is he's in the presence of the Attorney General.
That doesn't matter.
We're about to have, by an acquiescence by silence in this, and it is not...
An acquiescence by silence. Oh, that's always good legal theory, guys. Acquiescence by silence. That's real strong shit there.
Influences the Attorney General's...
The Attorney General agreed by saying nothing.
Backdooring hearsay.
Holy shit.
The witness hasn't even stated his name.
His silence damns him all the more. Holy God.
I just wanted to point out one thing. I'm not arguing with you at all.
You're a little bit arguing. I'm listening to you argue.
Understand that when we're talking about hearsay, this man is the witness. Hearsay is designed to prevent people from coming into court and repeating something that can't be cross-examined.
That's what you're asking for.
Cross-examined about the conversations that he had previously, but more importantly, he's there having a conversation with the Attorney General. The Attorney
General's not going to say anything.
Send him on the mission, and the Attorney General, by acquiescence, is acceding to the comment.
No.
Put all that together, I'd respectfully
no.
to reconsider.
Sustained. No.
And Your Honor, we're talking about a conversation with an unnamed witness on an unknown number on a sheet of paper we don't have.
Yep.
This is hearsay.
I agree. Sustained.
Try rephrasing the question one more time. Would you rephrase the question one more time?
There's no way he's going to get this right.
When you talked to the Attorney General, what did you tell him about your conversation, and what was his response?
Objection, hearsay.
Objection, hearsay, Judge.
Overruled. Continue. Answer the question.
Thank you.
I shared with the Attorney General that the random number he had provided me and the gentleman had yielded no helpful information to me whatsoever.
Did he know anything about what you were calling about?
The Attorney General?
No, the man you called.
No.
All right. And so when you told the Attorney General that, what was his reaction?
He shrugged it off and said, well, let's proceed anyways.
All right. Well, so you went and searched then for a requester, did you?
I enlisted
Well,
the
I suppose in that,
assistance of Ryan Fisher.
All right. So now, what would you need to be able to render this opinion that the Attorney General had requested?
Well, if we were going to issue an opinion to an individual, we needed someone who was authorized to make a request to our office.
All right. And were you ultimately informed that Mr. Fisher had, without going into what he said one way, located a requester?
Yes.
And who was the requester?
Senator Brian Hughes.
All right. Now, I want to be very clear. Do you have any evidence from any source or any reason to believe that at the time Senator Hughes was asked to be the requester, that he had any idea that that would benefit any particular individual at all?
No.
All right. And we're now 3 years later. Would it be your opinion that Senator Hughes had no idea that the request he's making might be used in a way that wasn't appropriate?
Objection to leading an improper opinion.
You have to let me finish the sentence.
It's the call of
excuse me, sir. I want it in the record. I finished the sentence. He could object, and the court can
Finish
rule.
the sentence. Finish the sentence.
Thank you very much. Even then or since, do you have any belief that you yourself, that Senator Hughes had any idea that by being asked to be a requester for an opinion, that opinion was going to be used to either help or hurt anybody else?
No, no basis for that.
All right. And of course, was Nate Paul's name ever mentioned in this at all?
The Attorney General studiously avoided using the name Nate Paul.
Objection to improper opinion.
Yep,
right.
I agree.
And then
I'd ask that the objection be ruled on, Judge, and to strike this witness testimony based on the ruling.
You're right.
Overruled.
now,
No, that's a wrong call.
when you then, what was the mission you were then going to have to do? After you got the request from Senator Hughes, and was the request done by text or what? Or did you have any contact with him or just with Mr. Fisher?
I did not personally have any contact with the senator, no.
All right. And so then what was your mission? What was your obligation to do?
My assignment was to prepare the opinion with the assistance of Deputy for Legal Counsel Ryan Vassar.
How were you going to do that? What were you going to do?
I assigned the research to Ryan Vassar. He began the process of researching on Friday, and the plan was for him to send me a draft the next day.
All right.
Saturday.
And when he did, what time of day? Well, when did y'all start conversing?
You're welcome.
Did you have conversations with him on
The
Friday
tech
night?
crisis.
I did speak with him on Friday.
Again, for
Who
those
was doing the drafting Friday night?
Ryan Vassar.
tuning in,
And what
I'm
were
wearing
y'all
glasses
doing
because
about
my
drafts?
eyes are sometimes very sensitive
Ryan
to light.
Vassar was
and this is
preparing
one
the
of those
initial draft,
times.
and then he would share it with me
So
by email.
save my
Now,
eyes
was the Attorney General involved
so
in
that
this
they don't
process at all?
bleed.
Initially,
I'm wearing
no,
glasses.
but subsequently, yes.
Your
When did he
tolerance is
become
appreciated.
involved?
Saturday.
And what happened Saturday that ended up getting the
Kurt is on no one's side. Kurt is trying to evaluate as things go.
What we believed was a satisfactory draft. We provided it to the Attorney General by email.
And when you did so, would you estimate what time of day it was?
It was late morning, if I recall correctly.
And what conclusion did you and Mr. Vassar reach as to what the answer should be?
Generally speaking, no, that the governor's orders would not prevent foreclosure sales from going forward.
And I'm not sure we've made clear just exactly what the mission was. What issue were you researching and going to issue an opinion on?
Whether or not the governor's COVID orders would preclude foreclosure sales from taking place.
And was there a limit? Was it a location?
My recollection, and again, it's been a while, is that these foreclosure sales generally happen in person on a certain day of the month. And there was a question as to whether or not guidelines governing the number of persons who could gather in one place would prohibit or restrict a foreclosure sale from going forward.
And the issue of the numbers of people as to whether they could gather here was what? Do you remember the numbers?
Oh, the governor's orders?
Yes.
There were county, city orders, the governor's orders. The number 10 sticks in my mind, but that was my recollection.
And were these foreclosure events to occur outside?
Yes.
What had been, as of the July 31st, August 1st time frame, the Attorney General's office's position and the Attorney General's position himself as to whether events like this should be open?
Ideologically, we were vastly in favor of openness. We were looking for every opportunity to signal to the public that Texas should be open for business.
So if one were to close those foreclosure events, would that have been consistent or inconsistent with the position that the Attorney General's office and the Attorney General himself had been taking in the months before July 31st and August 1st?
Objection in proper opinion.
Excuse me. He's entitled to express whether...
I'm
Thank you,
Overruled.
Judge. Thank you.
It would have been contrary.
All right. Now, the opinion that you reached, what did you inform? Who called the Attorney General or whatever communication you used to let him know what your position was?
I emailed him the draft that Mr. Vassar had prepared and that I had reviewed.
And at that time, who signed the draft, or was it signed at all? Was it still a draft?
Still a draft, although if my recollection serves me right, it was set up for Mr. Vassar's signature.
All right. And so, and your conclusion was that you notified him of him in that draft was what?
Generally speaking, foreclosures could go forward.
All right. And then what response did you get from the Attorney General?
At some point that afternoon, he informed me that that was not...
What time of day and how?
Mid-afternoon is my best recollection.
What did he tell you?
That was not the answer that he wanted or that he was looking for.
So what did he instruct you to do?
The opposite, do the opposite.
Do you recall what he said?
It was effectively, this is not going to work. We need to do something very different. We need to write this a different way so that foreclosure sales don't go forward. And of course, he repeated his mantra about helping homeowners in Texas. And of course, at that point, I understood sort of what his argument, I mean, I could understand why he was arguing that, but he did say, let's reverse it and go this direction.
Let's reverse what?
The opinion that we had reached.
And so what did you and Mr. Vassar do?
We wrote it the way that the Attorney General had asked. I specifically asked Mr. Vassar if it was an 80-20 or 90-10 proposition, if it could pass the laugh test, and he thought he could write it in a way that would pass the laugh test.
And when you, had you begun to wonder why he was so involved in this?
It was very uncharacteristic for the Attorney General.
Pardon me?
It was exceptionally uncharacteristic for the Attorney General to be involved in an opinion like this.
Now, so what did you guys do to go draft the opposite opinion that you just delivered?
I assigned it to Mr. Vassar, and he got to work.
And how did y'all get to work? What were the next 7 or 8 hours like?
He prepared the draft. He sent me the draft. We edited it. I had provided it to the Attorney General that evening. He had some additional comments and requests for changes to the opinion. We worked past midnight.
How many times did you talk to the Attorney General?
Several.
Did the Attorney General initiate calls with you during this period of time?
Yes.
And if you had to estimate, how many times did the Attorney General reach out to you about the language of your opinion and what he wanted in it that night?
Multiple times. It was at least 3 or 4, probably more.
Would the phone records of going back and forth from your numbers be the best judgment? If they're not, if the phone records show calls that particular
Objection
night?
to leading an attorney testifying about facts, not in
Excuse me, I
evidence.
still get to finish the question.
I'm objecting to the line of questioning.
Excuse me.
Overruled.
No. How many times did the Attorney General call you with suggested language?
Several.
And then when he did that, were you at any time going back and initiating calls to him?
Generally speaking, I was calling Mr. Vassar, and yes, I do believe I called the Attorney General a few times, if I recall correctly.
All right.
Counselor, we're going to are you in a good position here, say another 5-10 minutes? Is that a good break point, or do you want to
Sure,
break now?
that'd be fine. I'm not going to be able to finish, I'm afraid.
Right, I assume you'd be back to, so 5 or 10 minutes?
Sure.
Is that,
That's great.
All right.
That's perfect. Thank you, sir. All right. Now, on this particular issue, what time in the morning did you guys complete the opinion giving the Attorney General the result he wanted?
It was after midnight.
Okay. And by the time midnight came around, how would you describe the Attorney General's conduct that night in terms of his involvement with you?
It was bizarre.
And why was it bizarre?
He was acting like a man with a gun to his head.
In what way?
Anxious, desperate, urging me to get this out as quickly as humanly possible. I was very concerned.
Objection is
by his
speculation, Your
behavior.
Honor.
Goes to his observation. He can answer the
Speculating about
question.
what Mr. Paxton felt at the time.
No, he can base it on his common
My
observation.
question
That's
is
fine.
directed toward his reaction and observation as to the way the Attorney General was acting.
overruled, continue.
Yeah, it's a perfectly fine opinion to
All of
ask.
those things. He was
It's within the competence of a
desperate to get it
layperson
out
to answer.
quickly.
Objection is speculation,
Did you-
Judge, and improper opinion.
Overruled,
Nope.
Counselor.
Did he
within
have
the scope of a
deadline
layperson.
For you guys, had he told you when you wanted to get it done by?
It had to be done that weekend.
Pardon me?
It had to be done that weekend.
Okay, now you keep the microphone. I'm sorry. Now, when were you supposed to have it done? When did he give you a day? Because I didn't quite understand your answer before. I apologize.
Yes.
What
It
was
had
your
to be
de-
done that weekend.
That weekend. Did he tell you why?
He continued to repeat his mantra that this is going to help homeowners.
All right. And did he explain to you any homeowners were in crisis by Monday morning?
No.
Did you yourself start connecting any dots as to what this might involve as a result of all this?
I began to form an opinion, yes, about what was happening.
And what was that?
He had asked us to completely rewrite the opinion, to change the conclusion. He had done so in a whirlwind of activity.
Objection and non-responsive.
It's
He asked
very
about his
responsive.
opinion.
I think it's very
Overruled.
Thank you. Go ahead.
Based on those observations, I was very given the fact that there had been no profit from prior interactions with the phone number he gave me. I was very concerned that something more
Objection
was
is
going on.
speculation.
Let me ask you this. I didn't hear that last answer.
I objected to speculation.
He isn't telling you what the thing
May I
is. He
point
just
out,
had a sense that something else
She
was going
can't
on.
get both of
I think
us,
it's fine.
and it's just a nightmare for the court
I'm
reporter.
objecting to sidebar, Judge.
Excuse me, sir.
Excuse me, both of you. You're correct. She can't record two people at one time, so try not to talk over each other.
Yes, Your Honor.
Thank you, Counselor.
Thank you. Now, after that, did you learn of any particular event?
It's equivalent to saying I thought
involved
something
Nate
was
Paul
amiss.
That would
Right? Something seemed
indicate
off.
a potential
That's within the
benefit from
ability of a
ruling that
layperson,
you
right?
were
You're not
involved
saying
in
what
the
that
issue.
thing is.
Objection to leading.
You know,
and
you're just saying
speculation.
something was wrong. That's not
That's what you learned.
speculation.
It's not speculation.
He insinuated.
I'm going to sustain that one.
All right.
Rephrase.
Thank you, Judge.
I'll just give rulings on these things in
yourself,
real time.
Also find out anything about Nate Paul and foreclosure event.
Objection to relevance
No,
I
that
think it's
doesn't
very
work.
relevant.
and speculation as well, Judge.
I don't know if it's
very
speculative or
relevant.
not. If he knows, he knows.
I'm sorry.
Rephrase
very-
one more time.
Yes. Did you yourself ultimately discover a benefit to Nate Paul from what y'all had done?
Yes.
And what was that?
Objection to lack of personal knowledge. He has not laid the foundation to show how Mr. Banger would have found this out, Judge. So lack of personal knowledge.
How did you find it out? Ask the foundational question.
I don't know how, if he knows it and he learned it, he can then challenge.
Ask
how
the
he learned
foundation
it, he can
question.
challenge
Ask the
that.
foundational
But
question.
whether or not he learned of a benefit to Nate
Did you
Paul,
find out? Yes. How?
I don't know what the objection to that is.
How is the only word you need to ask?
I'd be happy to take him on board higher, Judge.
Literally one word.
Sustain
How?
it.
Now,
Did you find out what they were discussing that involved Paul? Yes.
ultimately,
How?
Did you have any more?
There's your foundation. Done.
You've explained that it was contrary to the law as y'all researched and issued your first opinion, correct?
It was not the best interpretation of the law by a long shot.
Had the Attorney General ever inserted himself in a particular opinion during the time you were there?
Objection is speculation.
No. He would know, if you know.
It's whether he knows of any time ever the Attorney General had ever interfered with an opinion like
Yeah,
this.
it's not speculative. That's bullshit.
Next question.
I oversaw the opinion committee
Pardon me?
for over a year, and in my time overseeing the opinion committee, he never interjected himself in that way.
During
There
that
you
year
go.
you were there, had he ever interfered with the conclusions that the opinion committee or anybody working in that committee had issued?
On occasion, he would have suggestions, but the degree of interference here was completely unprecedented.
Had you ever had him participate in the actual drafting of an opinion?
No.
In this particular time that you were talking to him, and were there any, on that Saturday, how many times would you estimate that he would call and ask you how much longer?
Toward the end, it was repeatedly. He would text me. If I recall correctly, he also called, but it was a constant stream of communications.
And did he ever send back to you some suggested change in language?
They were by phone call.
All right. Did he ever call and discuss any change of language?
Yes.
Had you ever experienced anything like that with the Attorney General?
I had not.
The final particular opinion, who initially signed it? At first, which one of the two of you signed it?
Hi, Matt. Welcome back.
It was set up for Ryan Vassar's signature initially.
Did the draft have that for him to sign it?
We're talking about this opinion of the Attorney General thing, which may or may not legally be an opinion of the Attorney
For
General,
what reason?
and the degree to which the Attorney General himself was apparently directly and very anxiously involved, according to this witness. That's where we're at. According to this
At the end of the
witness, the
process, I
Attorney
had
General
become
doesn't
very
normally get
alarmed
involved, and
by
the Attorney General got
behavior.
extremely involved
I
and
had promoted Ryan Vassar into that
wanted an
position
opinion
myself,
and then wanted it changed massively
and I
started
felt
doing
a degree of
drafting of this
responsibility to
opinion
him.
letter and stuff
He was still building his career.
in a
and
crisis
My
whirlwind-like
sense was if
atmosphere.
something broke bad with this, I did not want it to tarnish his career.
I think that's a good place to stop, Your Honor.
Okay, good.
Thank you, Mr. Harden. We will adjourn until 9 a.m. tomorrow morning. Thank
All
you.
right, great. All right, so I don't have very long because I'm gonna try to bounce out of here for something I've got at 7, and it's gonna take me a half hour to get there. So I've got about 5 minutes worth of wrap up. All right, so far I find this guy pretty credible, all things considered. So he has been testifying about this whirlwind session where they tried to get this letter out from the Attorney General. The Attorney General's like, I want an opinion dealing with foreclosure sales, because typically, and the counsel is correct, typically when there's a foreclosure, you meet at the place of the property, and that's where the auction occurs. That's extremely typical. So, like, not for at least a reason, everyone knows very clear about exactly what they're betting on because they're physically there. So he's like, okay, I want an opinion letter dealing with the governor had issued an order dealing with people gathering as a response to COVID. The Attorney General says, I want an opinion as to whether or not people gathering outside for the purpose of engaging in the foreclosure sale is foreclosed by the governor's order. So they go work on it, and the answer is no, this is fine. He takes note that at this particular point in time that the Attorney General's office has taken a position at this point in time, because this comes, I forget when he said it was. I think he said August or maybe September 1st of 2020, I think. So, like, while in the early days of COVID, the Attorney General had not taken a position on COVID, which, you know, fair enough, because in the early days of COVID, things were still dynamic. By this point in time, the Attorney General had taken the position that Texas would be open for business to the maximum extent consistent with safety. So they wanted the fewest restrictions possible. So the staff went off to write that. This apparently was on a Thursday. The Attorney General comes to him. I'm like, can you draft this memo They draft the memo and they're like, yep, no problem. And the Attorney General comes to them and says, no, that doesn't work for me. We need to completely go the other way on this. We need to reverse it. So he's like, okay, that's completely inconsistent with everything else we're doing, right? And then also now the Attorney General is getting directly involved with the writing and drafting of this thing on Friday and into Saturday because they stopped at midnight. The Attorney General apparently, by his story, is on the phone every 5 minutes with red line changes to this thing that are happening as it goes. And in a furry to make sure that it gets done in a massive way. And this guy says that, it's like the Attorney General had a gun to his head. He was anxious. He was just nervous. And he kept saying it's for homeowners. But this guy suspected something else was going on because he was the chair of the opinion committee. So he knows how, of course, they normally do that stuff, right? And normally the AG doesn't get involved. And sometimes they'll have some superficial notes, but nothing like this. Nothing on such an emergency, nothing to this degree. The Attorney General was interested in a frenzy way, in a way that was inconsistent with everything else they were doing, in a way that didn't make any sense. So that's basically what they're testifying to so far. So far I find his testimony very credible about the whole thing. And, we'll learn more as we go, but I find it very credible. So we will see how it all goes. So in Texas, foreclosure sales are on the first Tuesday of the month of the county courthouse steps. That sounds odd. That's all foreclosures are on the steps of the courthouse. Maybe you're right. That wasn't what I understood his testimony, but maybe. I mean, typically, and maybe you're right, typically foreclosures happen at the place of the property. All foreclosures in Texas happen at the place at the county courthouse? That sounds odd. So anyways. Same as in Georgia? Okay. Well, all right, fair enough. Maybe it was at the county courthouse and I misunderstood. Tax foreclosures? Maybe it's certain kinds of foreclosures are at the county courthouse. Check the Texas property code, not location. Okay. I run foreclosure sales for my business. We just have to put an ad in the paper, post it in the courthouse, then we have the sale on our storage lot. This is foreclosures for real estate. You're thinking about foreclosures for a storage unit. This is different. I'm thinking foreclosures for a house or like a business. I'm not. Yeah. So that's in a different category. So yeah. But then of course for you, the place of the foreclosure is the storage unit. Because that's the thing that's being foreclosed, right? In your example, the thing that's being foreclosed is the storage unit. So of course you would have it at the storage unit because that's the thing being foreclosed. Or am I misunderstanding your example? Let's see. Except as provided by law, a sale of real property under power of sale conferred by a deed of trust or other contract lien must be at a public sale at auction held 10 a.m., 4 p.m. on the first Tuesday of the month. Except as provided by subsection H, the sale must take place at the county courthouse in the county where the land is located, or if the property is located in more than one county, the sale may be made at the courthouse in any county. The Commissioner's Court shall designate the courthouse, blah, blah, blah. The sale must occur in the designated area, blah, blah, blah. Blah, 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 blah. Notwithstanding any agreement of the contrary, the mortgage service of a deed shall serve a debtor in default on a deed, blah, 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 blah. Written notice certified mail, blah, blah, blah. For the purpose of subsection A, the Commissioner's Court of the county may designate an area other than the county courthouse where public sales of property may occur within reasonable proximity to the county courthouse determined by the Commissioner of the court. Blah, 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 blah. So, yeah, it looks like in Texas you're correct. In Texas, you're correct. Apparently, they do occur at the county courthouse. So I just misunderstood his testimony. So fair enough. But that's okay. We can all learn something. Yeah. Anyways, I've got to go. I've got to go to class. So I will let you know how that all turns out. Until later, my friends. Thank you, Matthew, for the kind compliment. I appreciate that. We'll be on tomorrow, and we'll go from there. I've been Uncivil Law. Until later, my friends. I hope all's well. Cheers, my friends, and goodbye.